On August 14, 2021, Christopher Harvey dialed 911 from the home he shared with his ex-girlfriend, Rodrica Hill. He claimed that he just got home and found his girlfriend gravely injured, and that the back door of the home had been left open. The evidence, however, painted a very different picture. According to the evidence, Christopher Harvey was not happy with the breakup, and he was not happy that Rodrica started seeing someone else. The state eventually charged Christopher Harvey with Rodrica Hill's murder, claiming that he murdered the young mother due to jealousy. His interrogation has gained popularity due to his commitment to the story that someone else did it, although he admitted that he was mad at Rodrica because she had brought her new man to their home. So this is Christopher Harvey's trial for the murder of ex-girlfriend Rodrica Hill. Representing the state are prosecutors Brittany Fox and Andrea Diaz. Representing the defendant, Christopher Harvey, are Assistant Public Defenders Brooke Brewer, Amy Lim, and Dina Duncan. At his interrogation, Christopher Harvey seemed unhinged, and his defense story seemed implausible. Let's see if he has a better defense at trial, with the help of 3 members of the excellent local public defender's office.
All right, please be seated. We're ready to go back on the record.
Yes, sir. Yes, sir.
All right, let's do that. State of Florida versus Christopher Harvey, 2021 CF 2146. Defendant is present in the courtroom with his counsel. All their counsel are present. And anything before we bring the jury back in?
I don't have the case site offhand, Judge, but it came to my attention when Miss Lim was voir diring Dr. Clark, and she, said we would accept him as an expert, and the court kind of echoed that, he'll be accepted as an expert. There's some case law that says that, the court, and that's why I'm very careful by saying I tender, and I'm not offering him as an expert.
I said I was aware of that, and I said accept him as such.
Okay, all right. I just wanted to make sure
to not
that
use the word expert. Although I don't really understand that case law.
I don't either, because the jury instructions say expert witnesses, but I just don't want to get into a situation where it's, reversed on something trivial like that. So.
Right. Anything else?
Well, I guess there's one additional thing as far as Karen Knudsen, who will be after Felicia Bowen. I'm
sorry. I got to look at the names while you're saying them.
Oh, that's okay. So Felicia Bowen will be first, and then Karen Knudsen. Karen Knudsen's the FDLE latent print examiner. She examined the 2 9mm firearms, and developed one latent print of value on the Lorsin 9mm, Lorsin. It was identified via APHIS to a DeAndrew Scott. Detective Gaines looked into who that was, since it's not someone who was on the radar of this case. He's been in prison for murder since 2017. So there's no way he could have possibly committed this crime. He has an airtight alibi for where he was. I was originally not planning on even bringing that up, since it seems not relevant, and it's not even a possible suspect. The Lorsin is also not the weapon that was identified as being the murder weapon. William Black will testify later that the Lorsin wasn't even operational with the provided magazine. It had to be hand chambered. And then the Sig Sauer is the 9mm that was actually identified to the projectile from Miss Hill. I say all this to say the defense apparently wants that latent lift from the Lorsin to come out in evidence. So I will do that if that's their wish, because I don't want to have them bring it up on cross like I'm hiding something from them. But typically, with latent lifts on APHIS, it's improper for the state to, similar to a CODIS hit, to use that. We would go and get a 10-print card from Scott and have Knudsen compare that if we were actually trying to effect an identification. If the defense is wanting it in, though, I'm happy to do it that way and ask her if she got a hit from APHIS. But it's not how I would typically do it, and it's not what's typically proper.
Defense, do you have any comment on that?
Judge, it's relevant. It's part of her report and her analysis of the DNA on the Lorson and the Sigsaler. The report clearly states that there was a fingerprint that was listed, and in her analysis, she determined that it belonged to DeAndrew Scott. I don't intend to go into anything about him, but that it is part of her report that this name, DeAndrew Scott, was a determination she made as to a fingerprint that was on that firearm. It's relevant because it has the tendency to prove or disprove a material fact of these allegations of murder that the state is accusing Mr. Harvey of. The jury should be able to consider that.
That's fine. Okay. Yeah, I mean, I don't have any comment
Nope,
now.
that's
there's
fine.
any
If they want me to do it that way, I will.
objection otherwise. So ready for the jury then?
Yes, sir.
Okay, let's bring them in. All rise. Ready? Okay, please be seated and state if you could call your next witness.
State called Felicia Bowen.
Good morning, ma'am. Or good afternoon, sorry. Can you stand and face our clerk, raise your right hand to be sworn?
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
All right, and then just have a seat here. And state when you're ready.
Good afternoon. Could you please introduce yourself and spell your name?
My name's Felicia Bowen. It's Felicia, last name Bowen,
And how are you employed?
with the Leon County Sheriff's Office.
Do you have a specific role at LCSO?
I'm the latent print examiner.
Okay. How long have you been doing that?
Been in Leon County Sheriff's Office for 16 years.
Were you a latent print examiner somewhere else prior to that?
Yes.
Where?
Polk County Sheriff's Office in Central Florida.
So in total, how many years have you been examining and analyzing latent prints?
25 years.
Can you give the jury an idea of the training that's required to become a latent print analyst?
I have over 500 formal hours of training to include the science of fingerprints, how to evaluate and compare latent prints, different classes on techniques of how to process evidence to obtain latent prints, and we also do continuous on-the-job training.
Right. Have you had the occasion to testify to your opinions about latent prints in court?
Yes,
Approximately how many times?
approximately about 65 times.
Right. Can you give the jury an idea of what is a latent fingerprint?
The definition of a latent print is when an object or surface is touched by the fingers or the palms, an image of the friction ridge detail is transferred onto that object or surface by means of perspiration or some other oily substance, usually not seen with the naked eye and requires some type of processing to be able to develop it.
Is fingerprints and latent print analysis a subject matter that is generally accepted by the scientific community?
Yes.
And has it been for some time?
Yes.
Do you know approximately how long?
100 years.
I would tender the witness.
Any questions on that?
No question.
The court accepts the witness.
Did you have the occasion to receive some potential latent fingerprint lifts from Detective Chris Smith in this case?
Yes.
Right. What were your determinations as to these latent lifts?
I evaluated them and determined that they were of no value.
Can you explain what that means?
There wasn't sufficient enough ridge detail for it to be able to be compared to and possibly identified to somebody.
I don't have anything further.
Defense?
Yes, Judge, thank you.
Hi, Ms. Bowen. Good afternoon. So you became involved in this case to review latent prints, correct?
Yes, ma'am.
And these prints were given to you by Detective Chris Smith.
Yes.
When he's lifting prints, he does so by using a black powder substance on surfaces, right?
That's one of the techniques, yes.
And then any latent prints on the surface gets lifted onto a piece of tape.
Correct.
Those prints are then placed on what are called latent lift cards.
That's correct.
The cards will notate where the lift was developed from,
Yes.
like location.
Yes.
He gave prints to you on multiple cards.
I don't have that information. My report stated latent prints. Since they were of no value, our policy is to, we don't keep those no value prints, so I couldn't go back and tell you how many pieces of tape were on the card or how many latent prints were on the card.
But there were at least two, right? Multiple,
Yes.
plural. And like you just testified, it seems like you wouldn't be able, you don't know how many cards he gave you.
No, I don't have that information.
And so we don't have any record then of where exactly the prints came from that he lifted.
I don't have that information.
And you can't tell from memory of your reading of the card or anything like that as to where the prints were lifted?
No, ma'am.
Judge, if I could have a moment, please.
You may.
So your role is then you evaluate to see if there's any sort of possible identification, right?
I evaluate latent prints to see if they're of value to potentially be compared to and maybe identified to somebody.
And none of them were of value here.
Correct.
Nobody checked your work on this case?
No.
Checked your work on this case? I apologize.
No.
And none of the latent prints taken were able to be identified as anyone in particular's prints?
No.
That's all I have. Thank you.
State any redirect?
No, sir. Should be excused.
All right, thank you. You're free to go.
Thank you.
State your next witness.
Karen Kedson. Can I approach the clerk to retrieve some exhibits?
You may. Good afternoon, ma'am. I'm not sure. No, can you just stand up front? I'm sorry, I should have stopped before I got there. Just so you can stand and face our clerk and be sworn. Raise your hand. Thank you.
Do you solemnly swear or affirm that the testimony you shall be the truth, the whole truth, and nothing but the truth? I do.
All right, now, if you could just please be seated. Thank you. And state when you're ready.
Good afternoon. Could you please introduce yourself and spell your name?
My name is Karen Knudson, Knudson.
How are you employed?
I am a crime laboratory analyst at FDLE, Florida Department of Law Enforcement, in the crime lab in the Friction Ridge section.
Can you explain to the jury your qualifications for being, well, let me back up and strike that. What's the Friction Ridge section?
The section gets evidence, and we process the evidence for latent prints. And if latent prints are found, we will report out on our results, compare them out to known prints, and testify in court.
Okay. Can you explain to the jury what qualifies you and your educational background to be a latent print examiner?
I have 3 years of college. It includes an AA degree. I have additional courses in natural sciences and criminology. I have completed the forensic technologist program in both, it's a training program in both latents and photography, and I've also completed the crime laboratory analyst training program.
What does the crime laboratory analyst specifically for latent prints involve for training?
For training, there are two, it's about a 1.5 year training. There are 2 phases. Phase 1 is several hundred readings, competency tests, comparison tests, oral assessments, and the subjects are on an array of things, biology, intro to latents, comparison techniques, development and detection techniques. And then the second part is all supervised casework, where all my work is reviewed by a senior crime laboratory analyst.
How long have you been analyzing latent prints on your own outside of supervised casework?
About 7 years.
Is latent fingerprint, latent lifts, is that something that's generally accepted by the scientific community?
Yes, it is.
Do you know for approximately how long it has been?
I believe, I want to say one of the first cases was in 1911 where it was accepted into the courts.
Have you previously had the occasion to give your opinion as to your findings in court?
I have.
Okay. How many times?
5 times.
How many latent lifts do you analyze in a given year?
Thousands. A lot.
I would tender the witness.
Any questions on that?
No questions, Judge.
All right, the court accepts. Go ahead.
Did you have the occasion to analyze 2 items in the case that we're here for today?
There were 2 containers, yes. Sorry.
If you could take a look in front of you at States Exhibit 27 and 28. Exhibit numbers will be on the top of the box if you need to move them.
Yeah. They're mine. They're in this case.
Okay. What items did you analyze in this case?
So each item has a handgun, a magazine, and 3 cartridges.
Cartridges meaning a
Unfired.
live ammunition round?
Yes.
Right. I'd like to first start with the Lorson, States Exhibit 27. You can take a look at that. Do you recognize the packaging?
I do, by the case number and my initials.
Right. So is States 27 the Lorson that you examined?
I don't know your, may I refer to my file?
If you need to handle those boxes and look for your case number, you're welcome to.
Well, I can see the
Or
case
item
number. I
number.
just don't know your item number.
Oh, feel free to handle them. My item numbers are on a pink sticker. Yours are, yeah, I think yours on the back.
Okay, yes, States 27 is my 7.
All right. And that's the Lorson that you examined.
Yes.
When you obtain a piece of evidence in your lab to examine for latent prints, what do you do?
So for a non-porous item, such as a weapon like this, I'll first do a visual exam where I look for prints that are visible to the naked eye. I'll do a forensic light source exam where it looks for prints that will luminesce under a certain nanometers of the crime scene search. Sometimes you see them on TV shows. We look for that kind of search, see if a print will luminesce on its own. Next, I'll do the forensic, FSIS. It's a forensic full spectrum imaging system, and it has a UV light on it that will show prints that are not, you can't see with the naked eye. Next, I'll do cyanoacrylate or super glue. So I'll put the item in a chamber, fume it, and the fumes will adhere to perspiration prints on the item. After that, I do the FSIS again. And then after that, I do a dye stain, which will enhance the super glue prints and make them fluoresce under the forensic light source. And then lastly, I'll do a powder.
It seems like you're probably manipulating and putting items onto the item of evidence item of evidence that you're analyzing. Is there a specific order that you would get a piece of evidence, say, as opposed to a DNA analyst at FDLE?
Yes, we get everything after our biology section does for DNA because we destroy things.
Okay, including potential DNA.
Exactly.
Right.
Our UV light would destroy DNA, so we get it last.
All right. So for the Lorsen, did you run it through all of those tests you just listed?
I did.
What were your findings?
May I refer to my file, Your Honor?
If it would refresh your recollection, yes.
So for the Lorsen, under the forensic light source, after my visual exam, I actually had an inherent luminescent print on the handgun, so I photographed it. And then I kept going with my processes, and I photographed it again with my dye stain that was later near the end.
All right. And I'm going to publish a photograph that's already been entered into evidence. States 18 CC. Of that Lorsen firearm, since it's in its box. Could you tell the jury where that latent was found?
I'm not recalling which side, but it is on the grip of the gun.
Is that about where my cursor is what you consider to be the grip?
Yes, and probably it was on the edge, I know, like this inside edge where there was a more of a flat area.
What can determine whether someone leaves a fingerprint that is able to become a latent lift?
Well, you mean a print of value?
Yes, a print of value.
Okay, so a print of value has enough sufficient information along with the quality and quantity of characteristics in order to make the comparison. And that sufficient information includes the pattern type, the ridge flow, the incipient ridges, which are smaller hair-like ridges. They're underdeveloped. I look at pores, I think I said ridge edges. We look for creases. We look for scars, temporary damage, and the ending ridges, bifurcations, and dots.
Do you analyze...
Bifurcations, yes, ma'am. Sorry.
Do you frequently analyze firearms to see if there's presence of latent fingerprints?
Yes.
How often do you find prints of value on firearms?
I mean, often.
Okay.
I mean, not always, but...
All right. Are there surfaces that are more apt to leave fingerprints than others?
Yes, there are. A clean piece of glass would leave a beautiful print where a dirty brick probably would not have as much of a chance of leaving one behind.
What about specific areas of the gun? Like the grip is somewhat smooth. Is that where you located it?
Yes, on this one is. Most grips nowadays are very textured, and it's very difficult to get a print on the grip, but this one was smoother, so it was easier. Sometimes it's hard to get prints on the slide because of gun checks and people wearing gloves and all that. It smears the prints off, but there's always a chance, so we always try.
Okay. For the Lorsen, you said you developed, were you able to develop a print of value?
Yes, I
And
was.
that's the one that you were just showing us on the grip, near the grip?
Yes.
Right. After you have a print of value, what do you do?
So if I have a print of value and I don't have a listed subject or a standard, I will run it through our biometric identification system.
Did you do that in this case?
I did.
Right. Were you able to identify or locate a match?
I did.
Right. Who was that?
It is D. Andrew Scott.
Right. Did you have some type of ID number for him in the system?
It gave me an ID number, yes.
What was that ID number?
It's SID number 05995588.
Right. And can you spell DeAndrew Scott for us?
It's DeAndrew last name Scott.
Okay. And so once the system spits out a list of possible matches, is that how it works?
Yes, respondents.
Okay, then what do you do?
So I will go down that list of respondents and do a visual comparison on the screen to see if it is an identification.
Okay. Were you able to effectuate an identification of DeAndrew Scott for the fingerprint on the Lorson?
Yes, I was.
Okay. I want to move on to State's Exhibit 28, which should be the other item that you have in front of you. Do you recognize State's 28?
I do. By
How
my
do
initials.
you recognize it?
Yeah, my initials and the case number.
All right. Did you also, and what is State's 28?
That is one handgun, a Sig Sauer magazine, and 3 unfired cartridges.
All right, and I'm going to publish 18FF that's already in evidence of the Sig Sauer. Did you run the same procedure that you just spoke about for the Lorson on the Sig?
I did.
Right. What were your results on that?
I had, 1 minute. I just had ridge detail of no value.
And what does that mean?
No value means there are ridges present, but I have no sufficient information or not enough to make a comparison.
Where was the ridge detail that you were able to find located?
I can't tell you on that one.
You can't tell on this particular photo, or?
No, we don't note that in our notes.
Okay. If something's of no value, can you do anything else with it?
No, I cannot.
You can't run it through your biometric system?
No, there's not enough quantity there to do it.
Right. So no fingerprints of value on the 6 hour?
No.
Nothing further?
Defense?
Yes, Judge, thank you.
Go ahead.
Hi, Ms. Knudsen.
Hi.
Am I pronouncing your name correctly?
You are.
You testified that you found a print of value on the grip of the gun, of the Sig Sauer gun.
No, the Lorson.
Oh, I'm sorry, the Lorson. That's correct?
That is correct.
Okay. And that was a print that belonged to DeAndrew Scott.
Correct.
And there was a different analyst from another crime lab who verified this finding that you made.
Oh, in my lab. Yes.
And you didn't speak to any of the law enforcement officers about your finding in this case.
No.
That's all I have. Thank you.
State, any redirect on that?
Just briefly.
Go ahead.
So when you do make findings, what do you do?
So after I am done making either an identification exclusion, I will pass it on to another qualified certified analyst. And
No, sorry.
Nope.
Do you generate some type of report?
Yes, ma'am.
Okay.
I do generate a report.
Is that report with your findings then sent off back to the agency that submitted the items for review?
Yes, it
Right.
is.
So that report would have gone back to the detective, assumingly who sent off the items in the first place,
Yes.
for him to review and do any further follow-up.
Yes.
All right. Nothing further.
All right, ma'am. Thank you. You may step down.
Thank you.
State your next witness.
Hopefully he's out there a few minutes early, but it's William Black.
Okay, go ahead.
Permission to retrieve a couple more exhibits.
You may. Good afternoon, sir. Can I have you stand and face our clerk? Raise your right hand and be sworn.
Do you swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, then have a seat there in that witness stand. State when you're ready.
Good afternoon. Could you please introduce yourself and spell your name?
Good afternoon. My name is William Black, William Black.
How are you employed?
I work for the Florida Department of Law Enforcement, Tallahassee Regional Crime Lab.
What section of FDLE do you work for?
I work in the firearms section.
Can you give the jury an idea of how long you've been doing that, as well as the training and experience that you have that enables you to be a firearms analyst?
Yes, I've been in firearms with FDLE for about 11 years. In Tallahassee for approximately 9. I'm a crime laboratory analyst in the firearms section. My primary duty is to microscopically compare fired ammunition components in order to determine whether or not they were fired in the same particular firearm. This field of forensic science is known as firearms identification. Training for this position, well, first I have a bachelor's degree in physics from Florida Atlantic University. And with FDLE for my position, I completed an 18-month training program. This program included many hours on the comparison microscope, visitation of several firearm manufacturing facilities, and 6 months of supervised casework.
How long have you been doing casework on your own outside of supervision?
Since October of 2014.
Can you explain to the jury what firearms analysis is?
Yes. More specifically, the examination of a firearm or the microscopic comparison part?
Let's take it as we'll do one by one. So, do you have the occasion to test fire firearms?
Yes, I do.
What is that?
Well, that is part of a function test of a firearm. I examine firearms for operating condition. I examine their functionality, and I obtain test fires for standards for comparison against ammunition components that were also submitted in that case.
Right. And you mentioned microscopic comparison before?
Yes.
What would that be?
Well, when an ammunition component, such as a bullet or a cartridge case, is fired, it's left with microscopic scratches and impressions. And these marks result from contact with various interior surfaces of the firearm. And since the surfaces of the firearm are very hard, the same collection of marks is often reproduced onto each unit of ammunition fired in that particular firearm. Now, some marks are the result of predetermined design features of the firearm, and those marks are known as class characteristics. And some marks are the result of contact with microscopic random imperfections on the interior surfaces of the firearm. Those marks are known as individual characteristics. An identification is made when two similar ammunition components display the same class characteristics and corresponding individual characteristics. And this is determined through side-by-side microscopic comparison.
Is the functionality testing as well as the microscopic comparison that you just spoke of, are those each generally accepted in the scientific community?
Yes.
Has it been an accepted field in the scientific community for some period of time?
Yes.
Have you had the occasion to testify as to your findings in court?
I have.
How many times?
Approximately 60.
I would tender the witness.
Any objection?
Judge, I just have some questions.
Yeah, go ahead.
Hi, Mr. Black.
Hello.
Hello. Do you take any proficiency tests as part of your profession?
Yes, I do.
And how often are those?
Those are conducted annually.
So once a year?
Yes.
And are they conducted internally?
Yes, they're provided from an external source.
And what do you mean by external source?
They are tests that are created by collaborative testing services and sent to our laboratory. And our results are sent back to collaborative testing services.
And are there any sort of error rates that are posted by your agency on these proficiency tests?
They're not posted by our agency specifically, but there are error rates generated based on the results of the particular proficiency tests.
And we don't have any copies of those tests, do we?
No.
And do you have any sort of reports as to your own particular agency's error rates in this field of work?
No.
And do you have any reports regarding your own personal error rates in this field of work?
My personal error rate for proficiency tests I can give you is 0. I've never made a mistake on a proficiency test.
And what about in general, though, like when you're making your analysis of, when you talk about your microscopic comparisons, your test firing, do you have any error rates?
Unfortunately, error rates can only be generated from a particular test. They only can be representative of the results of a particular test.
Those proficiency tests, are they multiple choice questions?
No.
And you're saying that, oh, let's see. So have you written any articles on this subject?
I'm sorry?
Have you written any articles in this field?
I have not written any.
And so then I guess fair to say no peer review of any publications.
No. However, every case I work is peer reviewed.
And have you instructed any classes on this field of work?
I will be training a crime laboratory analyst in training at FDLE starting probably next week.
To become a trainer. Is that what it
well,
is?
I will be the trainer. I will be training somebody to become an analyst.
But no other training experience in the past, is that right?
I've conducted trainings on safety, checking firearms to ensure that they are unloaded. We just call that safety checking. I've performed that training 2 or 3 times.
And what was the name of the training that you said you were doing next week?
I will be training a new crime laboratory analyst in the firearms section.
Oh, I see. So a new coworker, is that what that is?
Yes.
I see. Okay.
I will be her primary instructor.
I see. Okay. So like a one-on-one sort of situation?
Yes. It is it's a quite long training program. I will be her primary instructor throughout this program.
And is there any sort of continuing education hours you need to complete as part of your work?
Yes, there are. I can't know specifically what the criteria is. Certain things count for hours of training. Yeah, that's the best I can answer that question.
Okay. I don't have any other questions at this time. Thank you.
Any objection? Defense?
Yes, Judge, we would.
Objecting to his status
Yes, Judge.
based on?
Judge, I believe it's maybe more appropriate at sidebar.
Sure, go ahead.
Judge, we are not stipulating to Mr. Black as an expert. We believe that this is a determination that the jury can make based on, or Your Honor, but we're not going to agree to that at this time.
The determination of his opinions on what he...
Correct, yeah. For him to be able to then provide opinions as an expert. We're not agreeing to that.
All right, that's
it.
all right.
Yeah.
Just for the record, that objection be overruled and the court will accept Mr. Black. Go ahead, State.
Is FDLE an accredited lab?
Yes, it is.
Right. And is the firearms section within FDLE also accredited?
Yes,
Right. And is it has it always maintained its accreditation?
it has.
Right. And you said you have proficiency testing that you do once a year?
Yes.
For how many years?
Ever since I've been working cases independently,
Is that like 10 years?
approximately, since the end of 2014.
And you've never failed one?
I have not.
I want to point your attention to this case and the analysis that you made. First, by 2 firearms that you received. Can you start by telling the jury what is a firearm?
Yes, a firearm is a device that is designed to fire a projectile by means of an explosion. That's basically a simple way of describing it.
What about a semi-automatic firearm?
A semi-automatic firearm is a firearm that requires only a separate pull of the trigger for each shot fired, after which a fire cartridge case is automatically ejected, and the remaining energy of discharge is what causes it to complete the remaining portion of the firing cycle.
How is a semi-automatic firearm different than a revolver?
The revolver, well, a semi-automatic pistol is fed by a magazine. Cartridges are loaded into a magazine, and then the magazine is inserted into the grip of the firearm. After each shot, a cartridge case from a semi-automatic pistol is automatically ejected from the firearm. Whereas a revolver, the cartridges are loaded into a cylinder, which rotates in order to fire successively. After the cartridge is fired, the cartridge cases have to be manually ejected from the cylinder of the revolver.
Right. You talked about an analysis that you do is called test firing.
Yes.
Approximately how many firearms have you test fired in your career?
Thousands.
Right. Turning to the 2 items in front of you, well, the 2 firearms in front of you, if I could have you take a look at First States 27, it's, I believe, your item 7.
Okay. Would you like me to open it as well?
You don't need to, unless you feel you need to.
I don't feel I need to.
All right. Can you tell the jury how you recognize it?
I recognize it by the unique FDLE case number, the item number, and my initials in my handwriting on the package.
Did you do a test fire of this Lorsen 9mm?
Yes, I did.
All right. And when I say 9mm and Lorsen, can you explain what that is to the jury?
Yes, this is a 9mm Luger caliber semi-automatic pistol, meaning that it's designed to fire 9mm Luger caliber ammunition.
What does Lorsen mean?
Lorsen is the brand of the firearm, the make.
All right. And I'm publishing what's already been admitted into evidence as States 18cc, a photograph of that Lorsen firearm. Did you test fire the Lorsen firearm?
I did.
All right. What were your findings?
It was test fired by hand chambering each cartridge and found to be functional. It did not function properly with the magazine that was submitted with it.
All right. And then publishing for the jury 18EE, the magazine of that Lorsen. So can you explain to the jury what hand chambering means?
Yes, as I said before about cartridges being loaded into a magazine for a semi-automatic pistol, and that magazine is inserted into the grip. When there is not a magazine present, or if the magazine present is not working, it can be fired one by hand loading the cartridge directly into the chamber.
And would that be by pulling the slide back?
Yes, pulling the slide back and then inserting the cartridge directly into the chamber.
And we're looking at 18DD, Where's the slide of that firearm?
The slide is where your cursor is resting.
All right. If you had to hand chamber each round before firing it, was that due to the magazine not functioning properly?
Yeah, something was going on with the magazine. The slide, I found at the time of testing, the slide would not retract when a loaded magazine was inserted. I tried it with 2 cartridges and then just 1 in the magazine. The slide was catching on something, possibly the cartridge. However, the slide would retract with an empty magazine inserted. It's just whenever it was loaded, I couldn't get the slide back in order to load and cock the firearm.
Okay, so if this firearm was found with the magazine inserted, would it have been able to fire any rounds from that magazine?
All I can testify to is how it performed at the time of testing. At the time of testing, as I said, the slide would not retract.
Okay.
Perhaps if the slide was retracted first and then a magazine inserted, I didn't try it that way, but
The only way you were able to fire it was by an empty magazine being in?
Yes, I ultimately just fired it, most likely with the magazine out and just hand chambering each cartridge.
Okay. So when you loaded the magazine that came with it, or any magazine, and tried to fire it, would it fire?
I only tried it with the magazine that came with it.
Okay. And would it fire?
It would not, the slide would not retract.
Okay. Does that mean it wouldn't fire?
Perhaps if there was one in the chamber and a magazine was inserted, I didn't try that, or at least I don't have that documented. Possibly.
Okay.
I couldn't say for sure.
Right. But at most, maybe if it was one in the chamber, it would only be able to fire that one in the chamber. It wouldn't be able to feed any up from the magazine.
Overall, go ahead.
The only way I tried retracting the slide was by hand. If it was the scenario that you provided, the slide would be retracting violently by force of the cartridge in the chamber being fired. I did not test that.
Okay. Is this a common issue with firearms?
I wouldn't call it a common issue, but I mean, we do run into firearms sometimes with magazines, with issues with the magazine.
All right. I want to move on to the Sig Sauer. It's State Exhibit 28, your item 8. Do you have that in front of you?
Yes, I do.
And how do you recognize it as the Sig Sauer you tested?
By the unique FDLE case number, the FDLE item number, and my initials in my handwriting on the package.
And what items did you receive in addition to the Sig Sauer pistol itself?
Inside the box was the semi-automatic pistol, a detachable box magazine, and 3 unfired 9mm Luger caliber cartridges.
Yeah, and you mentioned having unfired rounds with the Lorsen. At FDLE, during your analysis, do you use the rounds that come with the firearms?
Overall, go ahead.
Sometimes, but usually we use ammunition from laboratory stock.
Why?
Just because it's our ammunition, and that's usually just the standard procedure.
Okay. Similar to my question on the Lorsen, with the Sig Sauer 9mm, what's the manufacturer and caliber?
The Sig Sauer is the 9mm Luger caliber semi-automatic pistol, model P365. You said serial number as well?
No, I said the make and the caliber.
The make and the caliber.
Who's the manufacturer?
Sig Sauer.
Okay. And what type of rounds does it fire?
It fires 9mm Luger caliber ammunition.
Okay. Can a 9mm firearm fire any other type of ammunition? Any other caliber of ammunition?
A 380 auto can be fired in a 9mm Luger.
Okay. The rounds that were provided to you, what caliber were those that came with the firearms?
They were 9mm Luger.
Right. Right. So did you test fire the 6-hour 9mm
Yes, I did.
with the included magazine?
Yes.
Did it function properly?
Yes.
Right. Do you have any issues with it?
No, I did not.
Did you have to hand chamber it to fire it?
No, I used the magazine that was submitted with it.
All right, so earlier on you were talking about microscopic comparison. When you test fired the Lorsen and the 6-hour, did you retain any casings that you fired?
Casings? Yes, I did.
Okay, what about projectiles?
Yes.
Okay, can you explain the difference to the jury of a casing and a projectile?
Yes. The casing is the part of the cartridge that holds everything together until it is fired. The projectile is the bullet. The projectile is the part of the cartridge that is fired through the barrel and out the muzzle of the firearm. In a semi-automatic pistol, the bullet comes out of the muzzle, travels down the barrel, and comes down and comes out of the muzzle, and the cartridge case is automatically ejected out of the top of the firearm, top of the slide.
Are you able to take your controls of what you fire in the lab with these guns and compare them to items of evidence, projectiles, or casings submitted to you by a law enforcement agency?
Yes.
All right. And are you able to do that microscopically and affect an identification?
Yes.
Okay. And when we say affect an identification, does that mean that a particular projectile could have been...
Overruled.
Does that mean that a particular projectile could have come from any 9mm firearm, or it had to be that specific firearm in front of you?
When I make an identification, that means it is that my conclusion is that it was fired from that particular firearm.
Okay. And I think you talked about that previously, but why is that? Why are these things unique in that way?
Well, firearms are unique because they have imperfections inside of them that are randomly accumulated. These are typically the result of the machining processes that go into the manufacturing of the firearm component. However, other unique marks can arise throughout the lifetime of the firearm through use and corrosion, damage, etc.
So I want to start first with, let's do the Sig Sauer that we were just talking about. Were you able to, well, actually, let me back up and strike that. Did you receive some projectile or some fragments from law enforcement in this case?
Yes, I did.
All right, let's start with States 32, and I think that's your item 16.
Okay.
Okay. And do you have that item in front of you?
Yes.
Okay. How do you recognize states?
From the FDLE case number, item number, and my initials in my handwriting.
All right, and that's States 32. What is States 32 said to be?
One fired bullet.
Okay. And for the jury, I'm publishing States 35K, which is a photograph of States 32. What analysis did you perform on States 32, this projectile that's said to be from gunshot wound number 1, right cheek?
I examined it first for general information, such as its weight and diameter, in order to determine its caliber class. I examined the rifling characteristics of it, which are the class characteristics of that fired bullet. And I also examined its individual characteristics in order to determine whether it was of value for microscopic comparison to other items.
Was it of value?
Yes.
When we're talking about microscopic comparison, is this like a middle school microscope in science class?
No, it's more elaborate than that. I use a comparison microscope, which is essentially two compound microscopes joined by an optical bridge, which allows me to microscopically compare two separate items side by side in one magnified image.
Right. What were the class characteristics for this projectile?
This projectile was a 38 caliber class, which is includes 38 Special 357 and 9mm Luger, among others. It had rifling impressions that twisted to the right, and the widths of these rifling impressions were similar in width to that of the item 8 semi-automatic pistol.
Okay, so it was sufficient enough under the microscope that you were able to compare it to one of your test fired projectiles?
Yes.
All right. And did you compare it to the projectile that you obtained from your test firing of the Sig Sauer 9mm pistol?
Yes, I did.
All right. What were your findings when you compared this projectile with the Sig Sauer 9mm pistol?
The projectile was identified as having been fired from the pistol, the Sig Sauer 9mm Luger pistol.
And what was that based on? How did you make that identification?
This is based on correspondence and reproducing patterns of individual characteristics found on that bullet and on bullets that I test fired in the pistol.
From that same Sig Sauer?
Yes.
Okay. After you make an identification, do you do any comparisons with, like, the Lorsen, for example, to see if the Lorsen could have fired that projectile?
I did not make a comparison to the Lorsen because it was identified to the pistol. Also, I believe the class characteristics, the rifling characteristics of the Lorsen would not have matched that of the bullet anyway.
Okay. So once you make an identification, does that mean other firearms are excluded?
Yes.
In your opinion, could that projectile have been fired from the Lorsen?
No.
Okay. Could it have been fired from any other 9mm pistol other than the Sig Sauer that you have in front of you?
In my opinion, no.
I'd like to move on to States 33. Do you have that in front of you?
Yes. Yes, I do.
And I'm publishing for the jury what's in evidence is 35Q, which is a photograph of States 33. What is States 33 said to be?
4 apparent lead fragments.
Okay. And so we're looking at the item 35Q and evidence lead fragments from head missile gunshot wound number 2. Lead fragments from lead missile GSW number 2. Were you able to perform an examination on these projectile fragments?
I did examine these fragments, yes.
Right. What were your findings?
They are of no value for microscopic comparison.
And what does that mean? Why might they not be of any value?
They did not have individual characteristics, any marks from any apparent marks from a firearm present on them.
Okay. Did you also receive, back, should be in front of you, States 8?
Yes.
All right, and what is States 8 said to be?
Apparent biological material.
Okay. So was this sent to you by law enforcement to see if there may have been projectile fragments in it?
I believe so.
Right. Do you recognize States 8 in front of you?
Yes, I do. Same
Markings, labeling, initials?
Yes.
All right. What were your findings as to States 8, the projectile/biological fragments?
No items of firearms evidentiary value were found in that item.
Okay. Why might that be the case for projectile fragments?
Well, these didn't appear to. It didn't appear that there were any projectile fragments in that item.
Okay. What did it appear to be?
It appeared to be I put it as apparent biological material. What looked to be possible bone fragments, possible tissue, possible dried blood.
Okay. When a projectile hits something, what does it usually do? What's it designed to do?
Well, it can do a number of things. It could enter an object. It could bounce off an object. It could tumble. It could stay together. It could fragment. It depends what it hits.
Okay. And so depending on what it hits, we may have some projectiles that can be analyzed and are of value, and others that either have tumbled too much or hit bone or have fragmented too much.
Right. And there's also a chance that it's not a portion of the projectile that even touched the interior surface of the barrel.
Okay. All right. Let me ask you, would it have been prudent for your analysis to analyze a .32 caliber firearm to see if it matched the projectile?
No.
Why?
This projectile was not a .32 caliber class projectile.
It was a 9mm?
Yes, it was a .38 caliber class, which would include 9mm.
Okay.
Also, it was identified to a pistol.
To the 6 Sauer?
To a particular gun already.
All right, wait 1 minute. What about a .44 Magnum caliber? Is that also a different class than 9mm?
That is a different caliber class.
Okay. Would it have been prudent for you to examine a .44 Magnum caliber revolver for this projectile?
I don't think so.
Okay, why?
First of all, because I ultimately identified it to a pistol already. Also, I'm not sure. I'm not aware of any circumstance where of a .38 caliber class projectile being able to be fired with through a .44 Magnum.
Okay. Did that conclude the analysis that you completed in this case?
Yes.
I don't have anything further.
Any cross?
Yes, Judge.
Okay, go ahead.
Good afternoon, Mr. Black.
Hello.
So I want to make sure I'm understanding some things correctly about what you testified to. So as far as rifling goes, so this is basically like the series of grooves that are cut or formed in a bullet inside of a gun barrel, and when it's coming out in a spiral fashion.
Right. The grooves are in the barrel. They're cut or formed in the interior surface of the barrel. And those are meant for the projectile when it's fired to grip that projectile and spin it in a spiral fashion to stabilize it in flight.
And so when the bullet's coming out, it's going to have some grooves and different impressions on it as it's ejected out of the firearm, out of the barrel, because of how the barrel is situated inside, all the different things going on inside of the barrel.
Yes.
Okay. And so then that's when we get into what you were talking about with class characteristics and individual characteristics.
Yes.
So if I were to understand it in terms of like a hammer and a nail, when a hammer is nailing a nail in, the surface of that hammer is going to be different each time, maybe in microscopic ways, but it's going to be different each time that it hits on a nail.
The same hammer?
Yes, the same hammer.
Well, ideally the surface of the hammer, the tool, will not be changing each time it hits the nail.
Well, there's going to be little different grooves and marks in there that are formed each time it hits something different, correct?
Based on it maybe not hitting it perfectly the same each time? If that's what you mean. I
Yes.
agree with that.
Yes, that is what I mean.
Okay.
So, and then you testified earlier that when you make these comparisons of a fired bullet and a test fire, you're doing it through a side-by-side microscopic comparison?
Yes.
Okay, so you have the bullet that's recovered, and then you have the bullet that you're test firing from a gun that you're looking at, right?
Yes.
And then you're looking at those two together.
I am.
Okay, and so you're using, it's your eyes that are looking through the microscope to make your determinations.
Yes.
And the conclusions you reached in this case were from your own review of the marks, right?
Right.
And it's not a matter of quantity of marks in your comparison.
Not solely on quantity.
So in other words, there's not a number that you need to reach in order to determine that this bullet is going to belong to this type of firearm because of, X number of characteristics that you're finding.
Yes, correct.
And it's a subjective process.
It is.
You can't tell by your studies of the projectile and your test fire as to how many times a subject firearm has fired a projectile.
Well, each projectile is only fired one time.
Right, and maybe I didn't ask it very well. So the firearm itself, you can't tell how many times that firearm's been used.
No.
Is that yes?
No.
Okay, I just want to make sure we get it for the record. Thank you. And the inside of the barrel of a gun is going to change each time it's firing a projectile.
I think it's maybe a slower process than that. We find that a gun can be fired quite a few times and still produce the same marks on the fired ammunition components.
But the barrel inside is not going to be exactly the same every time.
I could not, I don't know if I can answer that any better. Perhaps, there is an erosive process going on, although it's very slow.
And all things that are happening inside of the firearm, that depends on the type of firearm too, right? Different models, different ages, those are factors into any sort of tool you're using.
It could be. Just the quality of the steel, you mean, and that sort of thing?
That could be a factor, yes, sir. Anything else that might be going on, but yes, like you raised, quality of the steel could be one of them. And let's see here. You testified that once you made a determination that the bullet that was item 16 from your report belonged or was compared to coming from item 8, that's when you stopped your analysis. Is that what you testified to?
Yes, that was, at least for that projectile, that was the end of it.
Okay. And so then no other test fires from other types of firearms were made, correct?
Correct.
And you didn't practice on shooting into any surface to see what sort of stippling might result?
Stippling from the gunpowder?
Yes, sir. From any type of firearm you might use, the sort of reaction it might have once it's shot into a surface. That wasn't part of your work in this case, right?
We're moving on from the discussion of the projectile. I mean, what I mean is the stippling would not have to do with the projectile.
As far as
no, I did not look for
okay,
it.
and that was
the shortest answer.
Okay, I appreciate that. Thank you. So no shooting into another surface to see what sort of physical reaction might result from that surface. And your answer is no.
My tests were fired into water.
Okay. You testified that with the Sig Sauer, so this was, the cartridges were placed into the NIBIN system. Do I have that right?
Yes.
Okay, and that stands for National Integrated Ballistic Information Network.
It does.
And then from that input, no potential associations here were made for those cartridge cases, for the Sig Sauer, correct?
Correct. Okay,
and then that's when you had to move on to making your own analysis with your microscope.
This was a separate analysis, the cartridge cases in NIBIN versus the comparison of the projectile, the test fire projectile to the submitted projectile.
Okay, but nothing else was made, nothing else was done after you put those pictures in of the casings and then no associations were made from NIBIN.
That's correct.
Okay. Now, you don't know how old that Sig Sauer was, right?
I don't.
Okay, and you don't know all of the different places it had been?
I don't.
Don't know all of the different people who may have owned it or possessed it?
I don't.
And with the Lorsen, also don't know how old this firearm was, right?
That's right.
Don't know all of the places it had been?
I don't.
Don't know all of the people who owned this gun?
I don't.
Don't know any of the people who could have touched this gun or possessed this gun?
No.
And if I'm understanding correctly, you didn't do a barrel cast of the Lorsen, right?
I did not.
Okay. And then so no other testing, like I think you've testified about, was done with the Lorsen in terms of comparison purposes?
Only the cartridge cases into the NIBIN database, NIBIN.
Okay. Now both the Lorsen and the Sig Sauer were the same size caliber.
Same caliber.
That's 9 millimeters?
9mm Luger.
And for you to begin your work on this, detectives had contacted you for your analysis, for your work. That's how you started this, was detectives contacted you.
I do not know if I actually spoke with any detectives on this case. Usually evidence is submitted to the lab from the law enforcement agency, and the case is assigned to the analyst. And when I'm ready to work that case, I get the evidence for that case from the evidence section. I don't necessarily speak with detectives for every case that I work.
I understand, and maybe I didn't word that the right way, so not in terms of speaking, but some sort of contact, like you're testifying about, like they're providing you with the information, the request to do this testing, just like they may be doing that with DNA analysis, fingerprints, that sort of thing. Is that fair to say?
It's fair to say.
Okay. And so you, in your assignment of this case, you were provided some preliminary information. Do you remember that? And if not, I can refer you to some documents to refresh your recollection.
No, there's some in here that was included in the file.
Okay, and so some of this information indicated to you that a plastic bag was recovered with a number of firearms.
I don't recall specifically. Sometimes I don't even read the synopsis that's provided in the file.
Well, so to you saying you don't remember, would it refresh your recollection if I provided to you some information that you've provided to us as part of your work in this case?
That'd be fine.
Judge, may I approach?
You may.
And for this, so Mr. Black, if you could look at the email that you received on Monday, August 23rd, 2021. It was from Gaines R. at leoncountyflorida.gov.
Oh, I do not, I'm sorry, I do not have that with me.
Okay, Your Honor, may I approach?
You may.
So, Mr. Black, what I've handed you is a document that you've provided to us as part of your notes in this case. Could you take a moment to look at that, and then when you've had some time to refresh your recollection, just let me know, please.
Yes, these are 2 pages that were included in my file when the items were submitted. This looks to be an email from someone named Robert Gaines to the Leon County Sheriff's Office evidence.
Yes, sir. And so there's some preliminary information that was provided to you. If you look at the second page of that document,
Okay.
there was the opinion that Detective Gaines gave to you that he believed that one of the 2 firearms in that bag was the firearm in the crime. Does that refresh your recollection?
I see it here. As far as recollection goes, I don't know if I've ever read that before.
But
I don't remember.
It was in all of your information that you included as part of your work in this case.
It was something that was provided in my file.
And you try to do a thorough job in everything that you do. Yes?
Yes.
I'm guessing. And so you would want to look through any information that was provided to you as part of your work in any case.
I don't think that having this information would be necessary to my working of this case, because my conclusions are based on my examination of the evidence.
Judge, may I have a moment, please?
You may. Yes.
Mr. Black, you are a member of the Association of Firearms and Tool Marks Examiners. Is that right?
Yes.
And so as part of your membership in this association, you need to stay up to date with literature and different conversations that go on about this field that you work in.
Membership for the Association of Firearm and Tool Mark Examiners requires training appropriate training for the field that I am in. It requires professional experience. And the Association of Firearm and Toolmark Examiners does put out a quarterly journal that does include papers that are published in that field.
And you keep up to date with different literature and papers.
Yes,
that
I
are
received
provided.
that. I received that journal.
Great. And so you're familiar with the National Research Council. It's the operating arm of the United States National Academies of Sciences, Engineering, and Medicine.
I'm aware that there is that they exist.
And it also puts out literature and that sort of thing and news for you to know.
Yes.
And in 2009, it had a report that concluded that sufficient studies have not been done to understand the reliability and reproducibility of the firearms analysis methods. You aware of that?
Is this the? I'm trying to think specifically of which report you're talking about. The National Research Council. I'm aware that there are papers that exist that say things like that.
And just to make sure, there haven't been any tests done to support the validity of your particular findings that you had in this case.
Well, there have been validation studies are performed, empirical and validation studies, using the same methodology that I use to perform this work here. However, am I getting the gist of your question correct?
I'm still listening.
This one, there wasn't any studies, any published studies performed on this particular examination that was carried out by me in this case.
And you're aware that the former analysis of bite mark science has been deemed a junk science?
I'm not aware of bite science.
Of bite mark analysis?
Bite mark analysis.
It's now a junk science.
Okay.
I have no other questions. Thank you, Judge.
Defense, any redirect?
Is bite mark analysis in any way related to firearms analysis?
I did not perform any bite mark analysis.
Okay. Is firearms analysis a junk science?
No, I don't believe so.
You were mentioning nothing had been done in this particular case to validate. When you guys do proficiency testing, I think you were talking about how that works. Are you comparing, like someone has already fired a known sample and you guys compare it so that you have an answer somewhere, you just aren't aware of it yet, right?
There is an answer that exists. I'm not aware of it.
Okay. But that's all controlled in a lab in a controlled setting so that there's validity to it.
Yes, that's controlled by, in our case, collaborative testing services.
All right. And so in every single proficiency testing you've done, have you been able to correctly identify which item was fired from the specimen they gave you?
Yes.
The defense was asking you about NIBIN. In order to have something entered into NIBIN, what has to happen? I mean, like, how do casings and stuff go into NIBIN?
Well, NIBIN is the, as we said before, National Integrated Ballistic Information Network. It's a database that collects images of fired ammunition components, primarily fired cartridge cases.
Is that primarily from crime scenes?
Cartridge cases from crime scenes can be entered into NIBIN, and we do that. We also enter test-fired cartridge cases from firearms that we examine into NIBIN, also in order to find a potential association with a previous entry. It's an investigative tool.
Okay. And so, like, if I went to the shooting range with a gun and I fired it, is the shooting range going to send off that casing to NIBIN?
No. I mean...
It's a law enforcement database based on crime scenes and previously recovered casings and projectiles used in crimes.
I'll sustain. Rephrase, please.
Is it primarily focused around projectile...
still leading.
Sustain.
Okay.
Press.
Is NIBIN something the members of the public submit to?
No, it's primarily cartridge cases submitted by law enforcement agencies that are from crime scenes. Also, primarily test-fired cartridge cases from firearms submitted by law enforcement agencies.
Were there any casings that were submitted to you to evaluate?
Not in this case.
All right. Are projectiles put into NIBIN?
Projectiles are put into NIBIN, but FDLE does not put FDLE does not put projectiles into NIBIN, only cartridge cases.
Okay. So you didn't have any cartridge cases to send to NIBIN other than the ones you test fired?
Right. The only cartridge cases in this case were the ones that were that I test fired in the pistols.
All right. And is it fair to say that with NIBIN, after you put something into NIBIN, it can spit out hits? Like you got a hit or a match on NIBIN, and it'll report back to you.
Yes. The way NIBIN works is I put the cartridge case into a machine, and it takes all these magnified digital images of the primer area of the cartridge case. The primer is the ignition component of the cartridge case. It's where the firing pin strikes. And that primer area is the area of the cartridge case that gets a lot of the marks that are produced from the firearm in the act of firing. So the machine takes digital images of that area, and then those images are sent off, and the computer looks at it, and it finds data points and everything like that, and it compares those data points to other images that are already in the system, and then it gives back a list of the entries from the database that it has scored the highest as far as being characteristically similar, for lack of a better term. And then I compare the cartridge case to those in that list in the system.
Okay. And so I guess my question though is, NIBIN can be useful, but only if the gun that you're trying to compare to,
Overruled.
if it has previously been fired during the commission of a crime, ejected a shell casing that was then submitted into the database.
Yes. I mean, if there's nothing in the database that was, yes.
When you're going through the defense stuff about rifling characteristics and things like that, do you have, as part of your analysis, do you take some snapshots of that side-by-side microscope that you include with your case file?
Yes.
All right. Do you also take some snapshots of, I think you mentioned you did a mold of the interior of the rifle of the 6 Hour?
I did include in my notes in this case a picture that I did have a picture that included the cast. However, that's not. I do not always. I don't always cast barrels. I don't always take pictures of it.
Okay. Would that help aid the jury's understanding in terms of what we've been talking about with a microscopic comparison and the rifling marks?
Perhaps. However, the rifling is the rifling are the marks caused by the grooves in the firearm. Those are the class characteristics. The marks that an identification is based on are smaller than the rifling. They're microscopic scratches, also known as striations. Those are the individual characteristics.
Okay. Permission to publish is demonstrative. Several photographs from his report. I don't have them marked yet, but I can.
Any objection to that?
It's page 21 of the bench notes. You need to follow along.
You may publish.
Okay. So what are we looking at in terms of what's on the left and what's on the right?
Just a moment.
Sorry. And it looks like it's written in your handwriting 13 of 16, if that helps you.
Thank you. Each of these images is an image taken on my comparison microscope that is of one of my test fires being on the left, separated by a dividing line, and the FDLE item 16 bullet on the right side of each image.
Okay. So on the left is the projectile that you obtained from your test fire of the 6 Hour.
Yes.
And the right is the projectile in evidence from the right cheek from the autopsy.
Yes.
Okay. And the striations you were talking about, those are these scratches?
Those are some of them right there, yes, that you were moving your cursor on.
And as we go down, is that an additional areas of identification on the same?
These are additional areas of correspondence.
Okay. Looking at the molding, what's this on the left?
This is a cast that I made of the interior of the pistol's barrel.
The 6 Hour?
Yes.
Okay. And comparing it to what on the right?
This is the bullet that was submitted.
Okay. So what's being made of the comparison in this?
This I included just for reference. The identification is based on the bullet to bullet, ultimately. But this is marks that I found on the cast that corresponded with marks on the projectile.
So rifling from the 6 Hour that would have caused these marks on the projectile?
Yes, these are imperfections inside of the 6 Hour that caused the marks.
Okay. And essentially, I mean, can we kind of trace the line from the left to the right?
Yes, that's the idea.
Oh. Now, as compared to the Lorsen, I think Ms. Lim asked you, well, but it's 9mm, so that's the same caliber as the 6 Hour. You were mentioning to me, though, that the Lorsen, you didn't really even need to do a comparison to the projectile because it had different rifling?
Yes, it did have different rifling characteristics than the 6 Hour.
Okay, the projectile.
Than the projectile.
All right. So the Lorsen firearm, the internal rifling of that Lorsen, didn't even match the projectile that you identified as coming from the SIG.
Right.
Right. And again, just so we're clear, what gun fired that projectile that was taken from the victim's cheek?
The 6 Hour 9mm Luger semi-automatic pistol.
That you have in front of you?
Yes.
No other 6 Hour 9mm Luger pistol could have done it except that one?
That is my opinion, yes.
Nothing further.
Judge, I may have a brief recross.
You may.
Thank you.
So the pictures we were looking at earlier, you were finding lines that looked similar, is that right?
Yes.
Okay, and then there were other lines on there, it's not up there anymore, but they were not lined up at all, right? Some are going down a little bit, the others are going up, that sort of thing.
Right, the photographs are not necessarily taken at the perfect place, at the perfectly exact same place in relation from the nose of the bullet and the base of the bullet, which could cause some in the photographs, some of the rifling to some of the actual shoulders of the rifling to not be in a line if they're at an angle.
And again, the only test fire you did was with the Sig Sauer, right? No other firearms.
I test fired 2 firearms in this case. Are you talking about the microscopic comparison?
Yes, sir.
The microscopic comparison was performed with the Sig Sauer.
And going back to the lines, one last question about that. I mean, so it all goes back to how this is a subjective process, right?
This is a subjective process.
Okay, that's all I have. Thank you.
Any follow-up to that?
Just one question. Is it a subjective process based on decades of science?
Yes, it's also, and that's why it's important to have training and experience in the field.
Nothing further.
Okay. So at this time, I'd like to take a afternoon break. Just please remember my instructions not to discuss the case or do any research regarding the case, and we'll see you guys back here in about 10 or 15 minutes. All rise for the jury. Please be seated. Anything for the record?
Yes, sir. No, Judge.
Are you going to be able to work ahead if you get through these next 3 witnesses?
Okay. No, sir.
Why not?
Because Maria Hyatt isn't even in town. She's coming back into town today, so she's not available. Gaines is extremely lengthy, so I'd have to cut him off. I don't think that I'm going to finish. I think it's still going to be pretty close to 5 by the time I finish. And I figured we could also take another look at the jury instructions.
Okay. Let's go off the record then.
10 minutes, Judge?
Yeah, that's fine.
Can I retrieve the exhibits?
Yes, please.
as I ended up doing that, I used it as a run dash with the folder. Yep. Okay. Meeting is a call.
All right, are you ready to go back on the record?
Dave's ready. Yes, Judge.
Okay, let's do that. This is State of Florida versus Christopher Harvey, 2021 CF 2146. Defendant's present in the courtroom with his counsel. All other counsel are present. And anything before we bring the jury back in?
Yes, Judge, we're ready.
Okay, we'll bring the jury back in then.
Judge, if I can have a moment to confer with State Counsel.
Go ahead.
Judge, we don't have anything right now. We're
Okay.
waiting for the jury.
All right, let's bring it back in. All right, thank you. Please be seated. State you can call your next witness.
Crumby.
Good afternoon, sir. Can you pause right there, face our clerk, raise your right hand to be sworn?
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
All right, then just have a seat here in that seat. And state when you're ready.
Good afternoon. Could you please introduce yourself to the jury and spell your first and last name?
Jamal Crumby, Jermell, Umbie.
Mr. Crumby, what city are you currently living in?
I stay in Jacksonville.
How long have you been living in Jacksonville?
6 years now.
Do you have ties to Tallahassee?
I'm from Tallahassee.
All right. Did you go to school here?
Yes, ma'am.
Do you still have family that live here?
Yes, ma'am.
All right. Who in your family still lives here?
All my family, like my mom, dad, and brothers.
All right. Do you also have a daughter?
I do.
Okay. Does your daughter live here?
Yeah,
Do you come here to visit her sometimes?
I do.
Do you still have friends here that you come to visit sometimes?
Yes, ma'am.
Okay. Do you know, or did you know, Rodrica Hill?
Yes, ma'am.
How did you originally meet Rodrica Hill?
I know I met Rodrica at NIM, 6th grade.
In the 6th grade. Did you guys go to middle school together?
Yeah.
What middle school is that?
NIMS,
NIMS?
middle school.
And if you can, just so that everybody in this courtroom has bad acoustics, speak up so that we all can hear what you're saying, okay? All right. Did you maintain a friendship with Miss Hill from 6th grade forward?
No, after 6th grade, we separated. She went to another school, and we got back connected in 2018.
In 2018?
Yes, ma'am.
How did you get back connected?
Facebook.
Okay. Did you continue a friendship with her from 2018 forward?
Yes, ma'am.
Did it ever develop into anything more than a friendship?
Yes, ma'am.
Right. Was it something that was serious? How would you describe it?
Well, she told me the situation with him, and I'm sorry, what was the question?
Was the relationship serious or was it casual?
It wasn't serious, just casual.
Okay. You were pointing over to a table and said him. Who were you talking about?
I think it's Christopher Harvey, ain't it?
Okay. How did you know of Christopher Harvey?
I don't know.
Did you know of him?
I just knew what she told me.
All right. Was that, without getting into what she said, did it have to do with who she was dating at the time or who she was going out with? I mean, who did you know Christopher Harvey to be?
I just knew of Chris.
Okay.
Who she was talking to. Well, her ex-boyfriend.
Okay. Her ex-boyfriend?
Yeah.
Right. Did you ever have any interactions with Mr. Harvey?
No, ma'am.
Okay. Did you know him from school?
No, ma'am.
I want to turn your attention to August, the 13th, going into the 14th of 2021. Were you in Tallahassee?
Yes, ma'am.
What were you doing in Tallahassee?
I was here to do some school shopping for my daughter.
Okay. And while you were in Tallahassee, I mean, how frequently would you come here to visit?
Every other month.
When you came to visit, would you see Miss Hill?
Sometimes.
Right. Not every time?
Not every time.
Okay. At that point in time, in August of 2021, how would you consider you and Miss Hill's relationship? Were you dating? Were you just friends?
We were just friends.
All right. On August 13th of 2021, did you and Miss Hill make plans to meet?
I guess.
Okay, well, you might not remember the date, huh?
No.
Okay. Was there an occasion in August that you and Miss Hill met up at a motel in town?
Yes.
Okay. Do you remember did it start, I guess, can you talk to the jury about what you and Miss Hill's plans were that night?
We were just going to hang out.
Going to hang out. Okay. Was it going to be at a specific motel?
Yeah. The first time I got in town, she had a different hotel. But I guess Chris found out about it, and I went and got my own hotel room.
Okay. And so I guess you said that when you first got in town, she was at a different motel?
Yes, ma'am.
And you never went to that motel?
I did, but she called me back and told me, I guess he found her.
Objection, Your Honor, hearsay.
Effect on the listener.
Objection, Your Honor, initial statement is hearsay, what she told him.
Sustained. Jury will disregard.
Okay.
Continue.
Is there a reason you decided not to stay at that hotel? I mean, why did you go to a second hotel?
She got the first hotel, and I guess he found out about it.
Objection, Your Honor. Speculation.
Overrule.
Okay. So because of that, because that's what she told you, did you change your plans and do something else?
I went and got my own room.
Okay. At what motel?
I went to the Days Inn.
Days Inn. Do you remember where that was?
On Parkway.
Appalachia Parkway?
Yes, ma'am.
Do you know if that's in Leon County?
Yeah.
Okay, it is. So was that, when you say you went to the Days Inn, is that the first or the second motel that you went to?
The second.
Do you remember what the first one was?
I don't remember the name of it.
Do you remember where it was?
It was on Capital Circle Northwest.
Capital Circle Northwest? Okay. And so when you got to the Days Inn on Appalachia Parkway, did Miss Hill meet you there?
Yeah, she came, yeah.
Do you remember about what time it was? I mean, was it daytime, nighttime?
It was nighttime.
Nighttime. Yeah. What did Miss Hill drive at that time?
A Mazda.
Do you remember what color?
It was white.
White. What did you drive?
A Charger.
A
A Dodge Charger.
what color?
White.
Sorry?
White.
White Dodge Charger. Okay. So you said you went and got a room at the Days Inn.
Yes, ma'am.
All right. Once Miss Hill met you there, did you guys share a room? What happened?
When she got there, I ordered a pizza, so I waited for the pizza to come. And it came, I had a couple slices, and I was finna retire for that day, so I was finna lay down. So, finna retire. So I laid down, and we was laying down, and that's when I heard the screeching of the tires that made me get up and look out the window.
Okay, let me pause you. So you went from you ordered a pizza to we were laying down. So at some point in time, who joined you in the room that you reserved?
Like I said, I got the room. She came. I already had ordered a pizza. It was already on the way. So the pizza came. I ate a couple slices.
So was Miss Hill with you in the room?
Right.
Right. Were you guys, I mean, were you just hanging out? Were you
Right.
planning on doing anything romantic?
Yeah.
You were, that was the plan?
Yes, ma'am.
Okay. Did it ever get to that point?
No, ma'am.
Right. Why not?
That's when I heard the screeching of the tires.
Okay. When you heard screeching of the tires, what did you do?
I looked out the window.
And what did you see when you looked out the window?
Him, Chris, and getting out his truck, talking to people downstairs.
Could you hear what he was saying?
No.
Could you tell, like, his demeanor, how he was acting?
Yeah, like, he was mad.
He was mad?
Yeah.
All right. What was he doing that made you think he was mad?
Like I said, it was just his body language talking when he was talking to the bystanders down there. Just moving fast, trying to, I guess, catch her.
Do you remember, was your room on the ground floor or
Second floor.
Second floor? Okay, so when you say second, because some people say 1 and 2 versus ground 1 and 2, what the parking lot is ground level.
Mm-hmm.
Do you consider that the first floor where the parking lot is?
Right.
Okay, so you were on the second floor.
Right.
All right. And where was your window facing?
Right there. Right. Looking at him.
Looking at the parking lot area? All right. Did Miss Hill ever join you at the window?
Yeah.
All right. What was her demeanor?
She was acting scared.
Acting scared? Can you describe that? Like, how did you know?
She just turned pale when she first came to the window and she seen him. She just went pale, went to getting her stuff together.
Okay. What stuff did she have with her?
Clothes, a little boom box.
What?
A boom box.
A boombox and clothing? Was it in a suitcase? Was it?
Nah, I think it was just a bag, like a bag.
Like a purse?
No, like a little tote bag.
Okay. And so you said she went to get her stuff?
Mm-hmm.
And what did she do?
I was looking, I was still watching him the whole time. And she was grabbing her stuff together. And as soon as he backed up out of our view, that's when she left the room.
Okay. And you said as soon as he backed up out of our view, did you see what kind of vehicle he drove there?
Yeah, it was like a little white dually truck.
White dually truck. By him backing up, did he get back in the truck, or are you talking about just on foot out of your view?
Yeah, he got back in the truck and backed up out the view.
Okay. What did she do?
Well, when she seen that, that's when she left.
Okay. But you stayed?
Yeah.
Why were you staying there?
I mean, like I said, I mean, it was my room. I was finna go to sleep.
Okay.
And you know I was.
So, I mean, would you have had a motel room even without Miss Hill there?
Yeah.
That's where you were staying while you were in town?
Right.
Okay. Did Miss Hill ever come back?
Yeah.
Okay. So what was the next thing you remember after she leaves? I'm sorry. Mr. Harvey leaves and then Miss Hill leaves.
Right.
Okay. What happens next?
I was watching him. I watched her leave, and I just kept watching. I stayed watching for about 30 minutes. I didn't leave the window.
Okay. Did Mr. Harvey come back?
Yeah.
Did Miss Hill come back?
No. She came back. I'm sorry. So when he left, she left.
Okay.
And when she left, I stayed in the window watching him. So because he came back after she left and was talking to the same people downstairs, was like, I guess he was saying, where did this car go?
You guessed what? I'm sorry.
Where did this car go?
Okay.
Yeah. And they pointed around the corner, and that's when he ran and got in his truck and sped off.
And left again.
Mm-hmm.
Okay. What was the next thing you saw?
When he sped off, I tried laying back down and tried to contact her, see if she was all right.
Right.
And that's when she came back a couple minutes later, like 20, 30 minutes later.
Okay. And she came back into the room?
Right, yeah.
Was she still acting scared, or was she acting something else?
I don't know. She was like it was under control, but I wasn't feeling it. So.
Kind of too much drama at that point.
Yeah.
Okay. Too much drama at that point. Okay. So the two of you are back in the room again. What happens next?
She's just telling me she's sorry, hugged me.
She saw
She
what?
was sorry, and she gave me a hug,
Okay. Does anybody ever come back?
and she left. Nah, that was it.
She left. Okay. One of the times when Mr. Harvey was there, did either of you call the front desk?
Yeah.
Who was that? Who called?
I mean, 'cause she ain't want to tell on him. She ain't want to get the police involved, tell on him. So I was just like, he got to go. He doing too much. So at least call down to the front and tell him to come around here and clear it up.
Did you call down to the front?
Yes,
All right. And did you talk to them about what was going on?
I just was like, it's a dude acting wild. Can you come send somebody? Get on out of here.
Okay. Do you know if the front desk did send anybody?
Nah.
Okay. You never saw what happened if they did?
Nah, ain't nobody never come. I was still out the window. I was
Okay.
still looking.
All right. Did Mr. Harvey ever find the room that you guys were in?
No, ma'am.
Could you hear him, other than talking to the people, could you hear him doing anything else? Did he just stay there talking?
I couldn't hear him.
Okay. But I guess that was a poorly worded question. Did he ever leave from that parking lot area?
Did he ever leave?
Like, while he was at the hotel, while you saw him at the hotel, was he always in that parking lot area, or did he ever come upstairs or bang on doors, anything like that?
I think he tried coming upstairs, and he came back. After she left, he came back. He sped off behind her, and then he came back, and I seen him back into a parking spot for about 5 minutes, and then that's when the last time he left.
All right. What makes you think that he may have come upstairs?
I thought I heard him. Like, where you at? Where you at? Something like that.
All right. Did you ever hear any banging on doors?
Overall.
I'm sorry, did I what?
Did you ever hear banging on doors?
I can't remember.
Okay. All right. So, can you kind of give the jury an idea, how many times did, because we've gone back and forth a lot, can you give the jury the order of events from when you were at the motel room and Mr. Harvey drives in, who leaves and comes back? Can you give that to us all in kind of one answer?
I got to the room. I ordered my pizza. Rodrica showed up. And then the pizza showed up. And then that's when Chris showed up.
Okay. And then who left first?
Well, when we seen him back out, I guess he went to the office to try to find her. Because I think she said he found the first room she had.
Okay.
Stand.
And that's okay. So he leaves, that's time one, and then she leaves?
All right.
Okay. Does he come back after that?
Right. To see where she went.
Does he come back before or after her? If you remember.
When she pulled off, he came back after that.
Okay. And then does Miss Hill come back?
Yeah.
Right. Is that after Mr. Harvey is left again?
Right.
All right. And then she eventually leaves.
Right.
All right. Do you see her again?
After she came back and apologized and hugged me, nah, that was my last time seeing her.
Okay. You said that you were communicating with her that night. Was it by phone?
Text message, yes, ma'am.
Okay, on a cell phone?
Yes, ma'am.
What was your phone number?
850-322-6639.
6639?
Yes, ma'am.
All right. Do you remember what her phone number was, or at least what it started with?
407.
407. Did you know her to have any other phone numbers that she used?
No, ma'am.
Okay, just that 407 one.
Yes, ma'am.
All right. Were you aware of if she had a daughter?
Yes, ma'am.
And do you remember what her daughter's name was?
Naya?
Naya?
Yes,
Right. Do you know how that's spelled?
no, ma'am.
Okay. After she left the last time, you said you stayed in the room. What'd you do?
I laid down. Lay down for about 2-3 hours.
All right. Do you remember about what time, how late in the night this is? Do you have any recollection?
I want to say 1, 2.
All right. And where, do you do anything else that night?
No, ma'am.
Okay. Stay there, go to sleep?
Yeah.
All right. What'd you do the next, I guess not the next morning, but ultimately you wake up?
Right.
All right. Do you remember about what time?
I left the room around 6.
6 a.m.?
Yes, ma'am.
All right. And where do you go?
To my friend's house.
Okay. Where's your friend live?
Off Blackstone.
All right.
Off Bluntstown. Off Bluntstown Highway.
I'm sorry, what?
Off Bluntstown Highway.
Bluntstown Highway. Did you have the occasion to drive anywhere off Woodville?
I'm sorry?
Were you ever off Woodville Highway?
As a matter of fact, I think I did go to my mom's house. I went to my mom's house, and I left my mom's house to go to my friend's house.
Okay. And your mom's house is where?
Was
Off Woodville Highway. All right. Did you ever go to Miss Hill's house that night?
No, ma'am.
When she was leaving for that last time and apologized, did you ever see her again after that?
No, ma'am.
All right. How did you learn about her death?
Kenny called me.
All right. And you don't need to tell me what he said, but who's Kenny?
That's our other friend.
That's her what?
A friend.
A mutual friend between you and Miss Hill?
Yes, ma'am.
All right. Do you remember when he called you and told you?
It was like, what, 10 o'clock, 11 o'clock, because I was at the mall. I just pulled up to the mall, and he called me and told me.
10, 11 o'clock at night?
No, it's the morning.
Okay, but you don't know what day it was?
This was the next day.
The next day?
Like, when I left the room at 6, that was that day.
All right. He told you sometime that day?
Yeah, around 10 o'clock.
In the morning?
Yes, ma'am.
All right. Are you sure about that time, or could it have been later?
It's from like 10 or 11, because the mall opened at 10, I think. So I think the mall opened at 10. So it was like 10 or 11, 12, no, I don't know.
Okay. And you said Kenny is just a mutual friend of you and Miss Hill?
Yes, ma'am.
All right. Did law enforcement contact you around the time she died to ask you for a statement?
Yeah.
Okay. Do you remember talking to them on the phone?
I forgot the guy's name, but
That's okay. You don't need to remember his name. But you talked to some law enforcement officer about this on the phone. All right. After you said you went to your mom's and then you were hanging out with a friend. Did you stay in Tallahassee?
No, I left.
And where'd you go?
Back to Jacksonville.
Okay, back home. All right. Nothing further at this time.
Me cross. Go ahead.
Good afternoon, Mr. Crumby.
Good morning.
Good morning. Okay. You knew Miss Hill from middle school, is that what you told us?
Yes, ma'am.
And you linked back up after a long period of time through Facebook, right?
Yes, ma'am.
Did you tell us that was in 2018?
Yes, ma'am.
So y'all have been back in touch for about 3 years?
Mm-hmm.
Is that a yes?
Yes, ma'am.
Thank you. And you had a sexual relationship, right?
Yes, ma'am.
Okay. And you told us that it wasn't a committed relationship, you were just having fun.
Yes, ma'am.
Okay. And sometimes you'd meet up in Jacksonville, right?
Yes, ma'am.
And that would be at your house?
Sometimes.
Sometimes,
Yes,
okay.
ma'am.
But when you would meet up in Tallahassee, it would be at hotels, right?
Yes, ma'am.
Okay. And that's because you knew she was living with another man, right?
Well, like I said, I didn't know She told me, well, she told me that.
Hold on, I'm sorry. I can't ask what she told you. I'm just asking you if you knew if she lived with another man.
No.
Okay. So you did not know that.
Well, no, I didn't know they stayed together. No.
Okay. You were under the impression that they didn't live together.
Right.
Okay, I understand. You had been to her house at least one time. Is that right?
Yes.
Okay. You picked her up there?
Yes.
All right. And on the night of August 13th to the morning of August 14th of 2021, you met up at the Days Inn on Appalachia Parkway.
Mm-hmm. Yes.
Yes. All right. And you'd met Miss Hill there before maybe 4 or 5 times?
Yes.
Okay. Now, you told us that you heard some screeching tires in the parking lot.
Mm-hmm. Yes.
Okay. And you previously told me that person came back and forth to the hotel 3 times.
Yes.
Okay. And in your estimation, that was in less than an hour. Do you remember that?
Yeah, I'm saying less than an hour.
Okay. Now, you were asked about talking to police regarding this case, right?
Mm-hmm. Yes.
And you did talk to a detective, right?
Yes.
Do you know how many times?
I think like twice.
Okay. But you never saw him in person, right?
No, ma'am.
Okay. And you never sent him any text messages?
No, ma'am.
And you never sent him any Facebook messages, right?
No, ma'am.
Okay. And you were never asked by him for your phone?
No, ma'am.
Okay. Just to kind of clarify the timeline, you left the Days Inn around 6 or 7 a.m. on August 14th of 2021.
Yes, ma'am.
Okay. And then, did you say you went to your mom's house or you went to Kamal's house?
I went to my mom's house.
Okay, you went to your mom's house first and then you went to your friend Kamal's house?
Yes, ma'am.
All right. And then you and Kamal went to the mall, right?
Yes, ma'am.
And you remember that because you were going to go get some school clothes for your daughter.
Yes, ma'am.
Okay, and you remember that you got there right around when it was opening, about 10 or 11 a.m.
Yes, ma'am.
And that's when you got a call from Kenny.
All right.
Okay. And Kenny told you that Miss Hill was dead.
All right.
Okay. Now, you have a twin brother, right?
I do.
And his name is Jarrell Crumby?
Right.
Okay. And you came back to Tallahassee the night, well, you were in Tallahassee the night of Miss Hill's funeral, right?
Right.
And you didn't go to the funeral.
No.
Okay. Your Honor, can I have just 1 minute?
You may.
No further questions.
The state, any redirect? Go ahead.
Getting further and further away. Alright. Mr. Crumby, do you know what Kenny's number is?
It's in my phone.
Do you have your phone on you?
I do.
Could you look at it and tell us what Kenny's number is?
It's 305. 305 986 7720.
7720. Is that the phone number he had back in 2021?
Yes, ma'am. I believe.
The defense asked you about a twin brother. Was he friends with Miss Hill too?
No, ma'am.
All right. Was he in town when you were there?
No, ma'am.
All right. I'm going to show you a ring video. Well, hang on. Let me back up. The defense also asked you if you picked her up at her house before.
See, that's the thing. I don't remember if I picked her up because I think she was just trying to show me the house.
Okay. Well, do you remember what road?
I don't remember.
What?
Well, it was off. Let me see. I can't even think of the road right now. I got a brain fart.
Okay. Remember, like, what year or month this was?
No.
Was it the night we've been talking about in August?
I don't think it was that night, no.
Okay. You didn't pick her up from her house
No.
that night?
No.
All right. I'm going to show you a ring video. It hasn't yet been entered into evidence. So I'm just going to show you. And for record purposes, it's going to be the ring video with the last 5 digits of the ID number as 56232. May I approach?
What potential exhibit would that be?
Oh, it's going to be from Exhibit 40A.
Okay.
Have you seen this before?
Mm.
No. Okay. Do you recognize that vehicle that's
Mhm.
pulling in?
Yes, ma'am.
Whose vehicle is that?
It's Drake.
Drake? Is that Rodrica Hill?
Yes, ma'am.
Okay. Is that her white Mazda?
Yes, ma'am.
All right. Do you see the person who's gotten out of the driver's side of the vehicle? Who is that?
It's Roger.
Rodrica Hill?
Yes, ma'am.
Do you remember what clothes she was wearing?
No, ma'am.
No? Can you, just so the jury knows, because they haven't seen this video yet, what was the woman who you identified as Rodrica Hill in that video, what was she wearing?
Objection, Your Honor. It's not entered in evidence. You can't comment on it.
I think he could refresh the recollection, but he said he doesn't remember, so.
He doesn't remember what she was wearing that night. All right.
He also has never seen the video.
No, he hasn't. We just looked at it. I mean, Sergeant Gaines hasn't testified, Judge, yet. I can go ahead and offer this into evidence under the business record exception, which I filed my notice, and I have the business records exception or affidavit as part of this composite, or it can be provisionally admitted in anticipation that tomorrow Sergeant Gaines will properly authenticate it. I'm fine doing it either way.
Any comment from the defense?
Yes, Judge. Judge.
On which basis?
On all the bases. We've never seen the video. He doesn't remember what she's wearing. We don't know what this is going to prove. It's irrelevant at this point.
I'll provisionally admit it. Go ahead, sir.
Permission to publish?
Yep, you may. This is 40A for the record?
It's 40A, but 40A includes 105 videos. So that's why I read the last 5 of the ID of the video that I showed Mr. Crumby. And again, for the record,
I would object to publishing it if you're provisionally admitting it.
Okay. The overall.
Right. And so for record purposes, I can read out the whole ID number. It's 6996-165-65263-195-6232.
Is there like a sequential number that would be?
It's the ring identification number, and there's a log that corresponds to the date and time, but that's how Ring identifies each of their videos.
So the next video would not be the next number? It would just be another kind of random 10-digit number?
Yes, the next video ends.
You don't
in,
have to read it.
Yeah, it's not sequential, unfortunately.
Okay.
The numbering isn't, at least. So, Mr. Crumby, when I asked you to take a look at this and asked if you were familiar with the car pulling in, whose car is that?
Rodrica.
All right, her white Mazda?
Yes, ma'am.
Okay. And are you able to identify the woman walking in to the front door?
Yes, ma'am.
Who is that?
That's Rodrica.
Rodrica Hill?
Yes, ma'am.
And you said you haven't seen this video before. Do you know where she's walking in? Do you know where she is, what this is?
It looked like she's at the house.
Okay.
She was got built.
Her house?
Yeah.
Right. Did you ever go to her house that night?
That night, no, ma'am.
Nothing further.
Any follow-up to that? Defense?
So, Mr. Crumby, and I'm sorry. You think you've been to her house one time before?
Yes, ma'am.
Okay, and you were able from that video to determine from a camera that's facing towards the street that that was her house?
Yeah, it looked like the house.
Okay, and how could you determine that?
I've seen the house before.
Okay. And in that video that we just saw, could you see the house?
From the way the street was looking, it looked like the same.
Okay. All right, thank you.
All right, thanks, sir. You may step down and state your next witness.
Officer Melina Muniz.
Good afternoon. Just come over here in this vicinity, and then you'll stand, raise your right hand to be sworn by our clerk.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
All right, and then just have a seat there in the witness stand. State when you're ready.
Good afternoon. Could you please state your name and spell it for us?
Melina Muniz, MELINA,
How are you employed?
I am a patrol officer with the Tallahassee Police Department.
How long have you been doing that?
A little over 2.5 years.
Were you working as a patrol officer for TPD back on August 14th, 2021?
Yes.
Did you get a call that led you to come out to the Days Inn?
Yes.
And what was the address of that Days Inn?
3100 Appalachia Parkway.
Okay. And were you aware of what the nature of the call was or why you were going out there?
Yes, an employee reported that a guest heard the sound of a loud boom. They believed it may have been a gunshot. And then there was complaints about people in the parking lot being loud.
Okay. Is Days Inn, because we've been talking to a lot of Leon County Sheriff's deputies, is the Days Inn you responded to, was that within TPD's jurisdiction?
Yes.
Okay. So it was dispatched out, but the call came to you guys because that's y'all's like beat.
Yes.
All right. When you arrived at the Days Inn, did you make contact with anybody?
I made contact with 2 subjects in the parking lot.
All right. Did you do any kind of investigation to determine if there had been a gunshot?
Officer Willis and I walked over to room 209, which is where they reportedly believe the gunshot came from or heard it coming from. The room was unoccupied. We didn't make any contact with anyone there. We didn't see any signs of shell casings, any signs of damage indicating that there had been a shooting. And then we spoke with the 2 subjects in the parking lot who both denied hearing any gunshots or anything that would have sounded like a gunshot.
All right. As far as any follow-up investigation, no crimes were being committed?
Correct.
Okay. So you kind of talked with them for a couple minutes and then left?
Correct.
All right. Did you have a department-issued body cam on while you talked to these 2 subjects in the parking lot?
Yes.
All right. Have you had a chance to review 2 still images from that body cam video that depict the 2 individuals that you spoke with in the parking lot?
Yes.
All right. And I have those marked as 38A and B. Are those 2 images a fair and accurate depiction of the 2 individuals in the parking lot you spoke with on the Days Inn on August 14th, 2021?
Yes.
I would move 38A and B into evidence.
No objection, Judge.
States Exhibit 38A and B are omitted.
Okay. Permission to publish?
You may publish.
Does TPD's body cam, does it put a date and time stamp at the top?
I believe so.
Okay. Have you compared the timestamp to your CAD notes to determine if it was accurate for when you were out there?
No, ma'am.
Okay, can you do that for us once we look at the timestamp?
Yes, ma'am.
All right, I'm publishing 38A.
I would say that's accurate.
2:22 a.m. on August 14th, 2021.
Yes.
Did you identify either of these individuals?
The subject to the right,
All right, who is he identified as?
Gary Knight.
All right, did you identify the subject on the left?
I did not.
Why?
The reason why I identified Gary Knight is because there was a question as to whether or not they were guests of the hotel. Gary Knight was the person that was on the room who was a guest, so that is the reason why I only identified him.
Okay. So Gary Knight had a legal right to be there, couldn't kick him out.
Correct.
And then this other gentleman was visiting Gary Knight?
Correct.
Or so he said?
Mm-hmm.
Okay. Moving on to 38B. So this is about, what are we, two minutes later? Or 10 minutes later? 2:32 a.m.?
Yes, ma'am.
Okay. And still the 2 same subjects?
Yes.
Subject on the left is Gary Knight?
Yes.
Subject on the right, the unidentified subject?
Correct.
What's he drinking?
Looks like an Ice House beer.
Okay. And is he on a phone?
Yes.
Are you able to describe the clothing that he's wearing, the guy on the right?
Looks like a dark t-shirt or polo, jeans, blue jeans, and black shoes, boots.
Black boots. Were you able to interact with him a little bit to see what type of hairstyle he had?
Yes.
What was that?
I would describe it as dreadlocks.
Okay. Were they long? Were they short?
I would say longer.
Okay. All right. And in 38A, he's standing in front of a white pickup truck.
Yes.
All right. Do you know what kind of truck this is?
Looks like a Ford.
All right. So how did you kind of finish up with these two gentlemen on scene?
After we established that they had a legal right to be there, that Gary was a guest there, we left the scene.
All right. Did you, tell them to keep it down? Was it kind of like go inside or?
We told them to keep it down. We told them that there was complaints that they were being loud.
All right, got it. Did you have any idea your body cam on this case was even connected to an LCSO case until much, much, much later?
Not until several months later.
Okay. So you didn't have anything to do with the homicide that would later occur or that was investigated by LCSO?
Correct.
It's just kind of happenstance that you were here and your body cam captured some images?
Correct.
Nothing further.
Vince, any cross?
Yes, Judge, thank you.
Go ahead.
Good afternoon, officer.
Good afternoon.
So when you made it to the Days Inn on Appalachia, you didn't hear any loud noises when you got there.
Correct.
And there were some still photographs that we just saw from the state of two men, one identified as Gary Knight, and then you later learned that the other man was Gary Knight's friend, right?
Correct.
And both of these men were cooperative with you.
Yes.
They remained calm with you.
Yes.
They didn't speed off.
No.
You didn't hear any tires screeching when you first came in.
Correct.
And you didn't see them speed off with tires screeching.
Correct.
They weren't disruptive when you met with them.
No.
And it looks like there were two different times you met with them, right? So in the parking lot and then up in the room?
Mm-hmm.
Or outside of the room?
Yes.
And that was outside of room 103?
Correct.
They didn't get defensive with you?
I would say no.
And they weren't aggressive with you?
Correct.
They didn't get angry with you?
Correct.
They weren't threatening to you?
Correct.
They were helpful with you?
Yes.
Answered your questions?
Yes.
And they were forthcoming with you?
Yes.
You've described them as appearing friendly to you?
Yes.
And at some point during your interaction with them, y'all shared some laughs together?
Correct.
As part of your investigation at the Days Inn, you talked about how you and other law enforcement officers made contact with other people. In this contact with other people, no one else could tell you that they heard gunshots, right?
Correct.
And you didn't find any evidence to support a shooting?
Correct.
Judge, may I have a moment?
You may.
Thank you. And Officer Muniz, you arrived at the Days Inn around 2:17 a.m., is that correct?
I believe so.
And if you need to refresh yourself, you can, but it sounds like you're agreeing with me?
Yes.
Okay. And then when you left, it was around 2:42 a.m., is that correct?
Correct.
All right. No other questions. Thank you so much.
State, any redirect?
Yes, sir.
All right, ma'am, you may step down. Thank you.
Thank you.
State your next witness.
We do have Officer Muniz under our subpoena, so I ask that she's not released from the entire trial, but our office will be in contact with you, officer, if you need to come back. Okay, thank you.
State, go ahead.
Deputy Michael Godwin. Amy, do you want to get your notes?
Oh, thank you.
Good afternoon, sir. Can I have you pause right there so you can stand and be sworn by our clerk?
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
All right, just have a seat there and state when you're ready.
Good afternoon. Can you please introduce yourself and spell your name?
I'm Deputy Michael Godwin, Chaelgodwin.
How are you employed?
I'm currently with the Leon County Sheriff's.
In what capacity?
At this time, I am a part of the transport unit with the bailiff unit.
Okay. Prior to this, back in August of 2021, what unit were you working with?
I was a crime scene detective in the crime scene unit.
Okay. And were you part of the team that was helping out with this case?
I was.
All right. Was one of your assignments to take some photographs of Christopher Harvey as well as buccal swabs?
Yes, it was.
All right. And do you remember when this was?
No, it was in 2021. Maybe August. I don't remember.
Okay. Would it be on your packaging?
It would be.
All right. We've heard a little bit about buccal swabs. Can you remind the jury what they are?
So buccal swabs is basically a swab of the inside of the cheek, and that allows us to collect DNA for processing.
Okay. May I approach?
You may.
Deputy, I'm showing you what I have marked as State Exhibit 36, 37. 36 and 37. And I'm going to give you those. Hang on a minute.
Okay.
Oh, no, I just have two 37s. All right, well, let's make that, what am I last number at, 52? All right, let's make that 53. A through F. Well, actually I have a better idea. Let's keep that 37A through F, and I'll make the right buccal swab 36B and the left one 36A. That makes more sense. Okay, may I approach?
You may.
Look at the two buccal swabs you have in front of you. They're now correctly labeled as 36A and 36B. And tell me if you recognize those.
I do.
How do you recognize, let's start with 36A.
36A is going to be the left buccal swab, and it's got the evidence tape with my initials, 5-digit identification number, and date.
All right, and the left buccal swab of whom?
That would be of Christopher Harvey.
Okay. What about 36B?
36B is the right buccal swab of Christopher Harvey, and also has my identifiers on it.
All right. Other than being sent to FDLE, have 36A or 36B been tampered with or altered in any way?
No.
Did you use proper protective equipment when you obtained the buccal swabs, changing out gloves to prevent from cross-contamination?
Yes. Anytime we do anything with DNA, we use gloves, latex gloves.
All right. Do you switch gloves when you're getting a separate sample?
Yes.
Okay. Did you do that in this case?
Yes.
All right. I would move 36A and B into evidence.
States Exhibit 36A and B are admitted.
All right. Do you see the man that you obtained those buccal swabs from in the courtroom today?
I do.
Can you identify him and point out an article of clothing he's wearing?
Black jacket, silver shirt, maybe.
Okay. There's 3 people sitting at that table. Is he what position
Sorry.
is he sitting in?
Yeah, second from the left,
From your left.
with long hair.
Got it. Well, there's a couple people with long hair.
Male.
There we go. Let the record reflect the witness has identified the defendant.
It still reflects.
All right. Did you also take some photographs of Mr. Harvey?
I did.
Okay. And is that kind of regular course of procedure? Why would you do that?
It is common procedure, especially when we are documenting a suspect of something, as even a victim at times. But it also allows me to document someone that's untampered at that time, and allows me to document it before I take any clothing or seize anything. We document for injuries or anything like that.
Right. And I think you should have the correct 37, A through F, in front of you.
Okay.
If you could take a look at those. What are 37, A through F?
These are documents of Christopher Harvey that I took in the criminal investigation.
So they're documents, or?
They are documented by me with my camera.
So photographs of him?
Photographs.
All right. Are they fair and accurate depictions of how he looked at the time you were meeting with him?
They are.
All right. Do you remember the date and the approximate time you were meeting with him?
I believe it was August 14th-ish. Without referring to my report, I can't tell you at the
Okay.
time.
Was it the same date the buccal swabs were taken?
Yes.
All right. And when were the buccal swabs taken?
August 14th of 2021.
Okay. I would move 37A through F in evidence.
State's Exhibit 37A through F are admitted.
Permission to publish?
You may.
And I guess I should ask, I know you said you weren't sure about time. Was this after LCSO responded out to Cathedral for the murder?
So yes, it was. It was after they responded out and then transported him to the office.
Got it. All right, so we're looking at 37A. This is just an overall photo?
Yes.
Okay.
Front photo.
What color shirt is he wearing now?
Gray.
Is he wearing, what kind of shoes was he wearing?
They were black sneakers.
37B, profile view.
Right side profile, yes.
Okay. 37D.
Back photo.
Okay. Oh, sorry. 37, sorry. I keep skipping letters today. That was 37C. 37D.
Left profile.
37E.
It's a facial shot.
37F.
That is photograph of some tattoos that was documented.
Okay. Was it also a photograph of his knuckles?
It was some documentation of what appeared to be old scarring of some sort.
Okay. No fresh injuries?
No fresh injuries to my knowledge that I saw.
Nothing further. Appreciate it.
Any cross-examination on that? Go ahead.
Did you say deputy?
I am deputy, yes.
Deputy, okay.
Now, yes.
Yes, sir. Thank you. Okay, Deputy Godwin, you collected 9 items from Mr. Harvey and put them in the evidence locker?
If that's what my report reflects 9, yes.
Okay. And you told us about the buccal swabs, right?
I did.
You collected the clothing
I did.
that we just saw in the photos.
I did.
To include a belt.
Yes.
And his underwear.
Yes.
And his socks.
Yes.
Okay. Now, you also collected a tissue with dirt from his fingernails.
Yes, ma'am.
Okay. Did you come up with that on your own?
No, ma'am.
Somebody told you about that, to collect that after an interrogation that was done of him?
I was informed that he was cleaning his nails and placing it on a tissue.
Okay. Did you see that yourself?
No, I did not.
Was he alone in a interrogation room?
When I got there, yes.
Okay. So previously he'd been with another officer?
He was.
Okay. And were you told by that officer?
I was.
Okay. And so you just collected it, right?
Correct.
Placed it in the evidence locker,
Yes.
and you don't know what happened with it?
No, I do not.
Okay. And other than, kind of just collecting evidence, you don't remember anything about his mental state or his demeanor. Is that right?
No, I didn't pay attention to his mental state or demeanor.
Okay. Just one moment, Your Honor.
Yep.
That's all the questions I have.
Any redirect?
Briefly, as far as his mental state goes, I mean, if it was something noticeable, would you have documented it?
Yes, I would have.
Like if he was falling to pieces, boo-hoo, crying, would you have documented that?
Yes.
Okay. He wasn't?
Not that I saw, no.
Okay. Nothing further.
All right, sir, you may step down. Thank you. Any other witnesses state?
Yes, sir. That's all I got for today.
All right, ladies and gentlemen, I think we'll have to call it there for today. Again, I just remind you, please don't discuss the testimony that you've heard or the case with each other. I'd also ask you not to do any research regarding the case, and we will see you back tomorrow, same start time, 9 o'clock. And thanks very much. See you then. All rise for the jury. All right, please be seated. Let's take a 10-minute break and then come back.
Are we going to do it for a conference?
Yeah.
Okay.
Okay, let's go back on the record, and it's 2021 CF 2146, State of Florida versus Christopher Harvey. Defendant's present in the courtroom with his counsel, and we're going to do the charge conference. So, is everybody looking at what I believe was 003 in the file name?
003, yes, sir.
Okay. Defense, is that what you have? It's just the case number, jury instruction 003 in parentheses. Is that the file name?
Oh, yeah, it does say, like, the title of the document. Cover your mouth. That was this morning. Yes, I've got them printed. I apologize for that.
Okay, I think there might have been two sent this morning. Whoops, because I forgot to send out, or forgot to include the two things I mentioned at the end yesterday. So I guess I'm kind of satisfied where they're at, so I'll just listen to the parties. The parties have any general comments first?
Yes, Judge.
What's that?
On the statement of charge, it's included the PFCF that is by the date now.
I'm sorry. Yep, you're right about that. Okay, I made that change. Anything else?
I have no comments aside from that on page 1. I'm sorry. Oh, it was me.
It was me.
I have no comments aside from that on page 1.
Sounds like you want to go page by page then, Stan?
Yes, sir.
Anything else, defense, on page 1? Page 2, anybody?
Actually, the 2018 current edit of the bar to say criminal premeditation, not premeditated killing. Would you ever know if this is movement?
I can look. I get them from the website, so. I assume those are the most up-to-date ones. It does say, in the elements it says premeditated killing, and then the definition is defined as killing with premeditation. I'll put that in there.
Oh, killing with premeditation. I see. On page 3.
Anything else?
I don't see anything.
It looks like that's the only difference between those two instructions, is what's in the quotes at the beginning. All right, anything on the lessers?
As to first-degree murder, I just, for record purposes, I believe heat of passion does not apply. I wanted to make sure defense wasn't requesting it, and that wasn't something we needed to litigate, because I know it's not included in this, in count 1 or count 2.
Defense?
No, I'm talking about forgive as applicable. It's not in here, it's in the standard instruction.
Defense, do you have any comment on that?
Yes, Judge. I think at this point, since we're not really to place evidence, I would request that we include the heat of passion before it's taken out of the answer.
Add it if it becomes applicable. But at this point in time, it seems like the defense's argument is he didn't do it. And even if he did, the facts don't support the heat of passion offense under Taylor versus State 316, 7th, 3rd, 420, 1st UCA 2021 that talks about mere marital squabbles are not sufficient for the heat of passion offense. I would argue against it.
Okay. Certainly don't think there's anything evidence of it at this point, but we can revisit it later if necessary. The possession aggravator, I think, is more appropriate after manslaughter, even though it doesn't apply to manslaughter. I'd rather get the two lessers defined before going into the aggravators. So any comment on the manslaughter instruction?
There's nothing for me in
State?
Wait a minute. So it looks like it's missing the culpable negligence. I would agree that we don't have facts that support intentionally procured an act, but I do think culpable negligence could potentially be an option.
Defense? Any comment on culpable negligence?
I'm fine about that.
So State, you're saying no matter how the evidence plays out, do you think that one would apply?
I'd be requesting it just because I think it's odd that the instructions without culpable negligence talk about how you can't have manslaughter by act with only mere negligence. So without the additional definition of what culpable negligence is, to me it doesn't make a lot of sense.
So you're saying every time a manslaughter instruction is given, it would also require a culpable negligence theory?
Maybe not every time, but I think in this case, if you review the definition of culpable negligence, it would apply to the facts of the case.
Well, you said the hook was that it said mere negligence isn't enough for manslaughter.
Well, that's why it doesn't make sense to me, but I'm requesting culpable negligence because I think it is applicable based on the definition of culpable negligence. That includes violation.
So like the gun discharged 3 times and the victim relocated during the struggle, and that would, you could still think that could fit a culpable negligence theory?
I think it shows reckless disregard of human life, which is what the definition of culpable negligence includes.
At defense, do you have a position on culpable negligence yet?
I don't know that I have an objection to it right now. I believe it's appropriate as it is.
So I'm having trouble understanding your position.
I believe it's appropriate as it is currently. I don't know that it's required. I mean, I don't believe it's required, and I don't know that it's supported by any testimony so far. So perhaps if you want to revisit it.
Okay, it's flagged for future reference. Now, the aggravator related to possession and discharge of a firearm causing death, I just made a change while we've been sitting here to add first or second degree murder to each time it says murder.
No objection to that. I'm correct.
I can't help you with that because everything's been moving around.
It's on original page 4.
It was before manslaughter before.
Karen, is that under the heading aggravation manslaughter?
No.
Or under possession and discharge?
Possession and discharge.
Okay.
So where it says murder in there, it just now says first or second degree murder.
Okay.
Otherwise, I think it's the same. Any other comments on that section?
Are you also talking about the carrying, displaying, using?
We can move to that next.
Okay.
So aggravation of manslaughter by carrying, displaying, or using?
So it also.
You want to add the other two?
Well, it just includes second-degree murder as well, so I don't know if it should just be limited in the title to manslaughter.
Yeah, just aggravation by. How about that?
That works.
Do you want to add the other couple verbs?
Yes, please.
What, are they in there? Oh. I think they are in the indictment, but
I usually put all of them in my indictments.
because I think I put them in the verdict form, but they didn't make it in this part. Okay, so I'll add the other two verbs. You following that, defense? So threatened to use or attempted to use.
I don't think we see any other changes for that section that Your Honor was describing.
All right, anything on the tampering?
Oh, sorry, and then I guess, are you gonna add second-degree murder or manslaughter with a firearm? Because right now it's just, you should find him guilty of manslaughter with a firearm.
Yeah, it's already in mine, so I don't know when I did that, but it is in there. Second degree murder or manslaughter.
With a firearm, and then same thing of only of manslaughter or second, I guess, only of manslaughter or second-degree murder.
Oh, I didn't get it in the second half of the paragraph though. Okay, anything on tampering?
No, sir, as long as everyone's fine with it just being the specific items listed in the indictment aren't included. I don't have a preference either way. Just want to make sure defense doesn't either.
Oh, how is it worded in the standard? I don't recall.
In the standard instruction, I think this is the standard instruction that you have.
Yeah, it didn't have like brackets that I've already
Right,
removed.
right.
Oh, okay.
Well, we can check. I don't think it does.
Yeah, what's the party's preference there?
I'm good with honest.
Okay, so on to plea of not guilty, reasonable without burden of proof, I think are fine. Should say indictment instead of information. Just then weighing the evidence. Any desire to go over paragraphs 6 through 10 at this time?
Yes, sir. I don't believe there is. I don't think any of them are applicable at this point.
Right. That looks about right, but I think we just wait on those. Accomplices and informants.
I don't believe it's applicable.
Is the defendant made a decision to testify or not? Or you want to discuss that at this time? Defendant's statements. I think there was at least a 911 call. So we leave that in. That's fine.
That's fine. I think it's geared towards statements to law enforcement. So
Yeah, probably. But, I mean, it is a consolidated dispatch, so.
fine.
What about verdict in single defendant multiple counts? Oh, there's information there. I'll change that to indictment.
That's just standard, I believe, right, Judge?
Yeah, there's always some edits in there about lessers but usually if, you get more than one count and a lesser, it's almost always in that bucket, so it's usually, it looks like it does now, I think. And the single defendant multiple counts, the only change that comes up in that one, I think, which came up recently, was the linked counts inextricably intertwined.
Right. I don't know that we have any of those in
Yeah,
this case.
so that part's been removed. But,
No objection.
and then there's the note paragraph is added to the submitting case to the jury section. But that's pretty standard. And the exhibits, I just said most of them will be sent back. If you want to look at any others, request that in writing. And I think that's flexible enough. We can kind of decide if there's argument as to what should go back. We can decide that later. But the way the jury's instructed, I think that's fine. There might be like some videos that can only be played in here or something. So.
Right. From my perspective at this point in time and what I anticipate introducing, the only items that wouldn't be allowed to go back would be the firearms.
So how does that work? If, for example, one of the things were opened, I don't recall which one, but something was opened, you use gloves to open it.
We can reseal it too. I can have my investigator come down and reseal it.
And so what's the benefit to the jury of getting like a sealed yellow envelope that you can't see through that has like a buccal swab in it, sending that back?
If they want to open it and see it, they could send a note to the bailiff, but it's there and it's an evidence.
And if that kind of stuff is going back, should they be instructed that it should remain sealed? Sealed evidence should remain sealed, something like that.
That's fine with me. I mean, unless if they wish to have it opened and view what's inside it, to send a note to the bailiff, something like that's fine with me.
All right, defense, do you have any thoughts on that? My concern is like if there's a conviction and 5 years down the road there's some kind of DNA issue, then the DNA should be preserved to the extent it can be.
Yes, sir. I mean, they're not allowed to open any of the physical items unless they specifically requested to view it.
Okay, I just don't think that's clear in here. That's what.
Okay. Yeah. I have no issue with an additional instruction.
This seems open season to me the way it reads. But.
I've never had a juror ask if they could. I don't even know if they had scissors back there, so I don't know if they could open it. But I've never had a juror open any of the envelopes. I've had juries request that an item be opened for them so they could see it.
Okay, so I just said sealed exhibit should remain sealed. If you would like to view anything sealed, please request that in writing.
No objection.
Okay. Now to the verdict form, anything?
No, sir.
Defense, do you have any comments on that? All right, so if we can move over to the bifurcated instruction. I don't think this changed much from our discussion yesterday, and I don't think there was anything outstanding from that. But do the parties have anything for that? Could you just walk through, because I guess I'm a little confused on the stipulation aspect. Assuming there's a conviction and they have to go to the bifurcated proceeding, can you walk through how you envision that happening?
So how I've done it in the past is by a written stipulation. With the stipulation instruction, and it was, a stipulation when parties agree that certain facts are true, For this case, you must agree that this fact is true. And it was,
So just on page 1 where it says by stipulation, put the beginning part before by stipulation. In this case, the stipulated fact that you must accept as true is the defendant was a convicted felon at the relevant time of this charge. With the charges? Or...
Yes, I think I would probably prefer that it would be like prior to August 13th, 2021, the defendant had been convicted of a felony. Just so that, because the relevant time of this charge, jurors do some weird stuff with stipulations, so I just usually try to be as specific as possible.
So that the stipulated fact that you must accept as true is the defendant was a convicted felon prior to the time August 13th, 2021.
That would work for me.
Defense?
Yes. And then is the actual possession instruction included? Because I see it on the verdict form as an interrogatory.
Yeah.
I don't think the actual possession instruction is in the instructions.
Yeah, it's on page 2. It says to prove Christopher Harvey possessed, quote, a firearm. Well, possesses in quotes, not a firearm.
Right. I think that's what we were talking about yesterday, how it has a different possession definition.
Yeah, I think that's the one from...
Right. But we'll need the additional, the aggravation of a crime by possessing a firearm. We need the actual possession instruction so that they can answer the actual possession interrogatory.
I guess I'm not following. So you think that to re-instruct them on aggravation, I'm not calling it aggravation, but aggravation by possession of a firearm, with the other definition, the one that was in the...
With the actual possession, correct, because it's the exact same mechanism that triggers the 1020 life. It's just a different sentence. So by the definition of possession that is currently in the bifurcated instructions, it could be constructive or actual.
Do you want to maybe pull up that statute real quick? It's 7,
775.087, subsection 2. And it's under
Q.
Q is firearm by felon, and then right under the paragraph it says, except that a person for possession of firearm by a felon shall be sentenced to 3 years.
So you're not going for the second sentence there that says, however, if an offender who is convicted of the offense of possession of firearm by a felon has a previous conviction of committing or attempted to commit, we'll call it an enumerated felony, and actually possessed. That's the 10-year one. You're not going for that one?
Correct. No, sir. That would not be applicable.
Okay. So that's what I was thinking of yesterday. So you think that the second definition of possession needs to be included because of that?
Yes, sir. Because as it stands now, it could be actual or constructive, and so they have to be instructed on what actual possession is, and then they make the finding of actual possession on the verdict form.
Okay, I think I understand what you're saying. The defense, do you have any comment on that?
I believe that's correct. They have to make a finding.
I'm sorry?
That's correct. Well, I say that, I see what you're saying is the knowingly actually possess, like it's in the standard CSTF instructions. Is that what you're talking about?
No. My recommendation, Judge, would just be to pull from the standard actual possession and discharge of a firearm the definition of to actually possess, which is to actually possess a firearm means that the defendant, and then there's two options, A or B.
Okay, so I just added a section that says actual possession of a firearm. It reads the same as the aggravator as in the original instruction, the main, the overall final instructions. It just says if you find that Christopher Harvey committed the crime of possession of a firearm by a convicted felon, and you also find beyond a reasonable doubt that during the commission of crime he actually possessed a firearm, then you should find him guilty with actual possession. The firearm's been defined for you, but I just redefined to actually possess a firearm just so it's clear. Because we just told him like 3 or 4 paragraphs up to possess the firearm, so I just want to clear that. They're 2 different definitions.
No objection to that.
And then it says all the same rules apply, and then a verdict form's been prepared. All right, anything else? I added the stipulated instruction, so the same from 2.3. When the parties agree that certain facts are true, it's called a stipulation of fact. Do the parties want that in the main? Because there was those 2 stipulations, and I would prefer to send the stipulations back with the jury, just as they are now. So we can give the stipulation instruction and the main final instructions just to help them understand what stipulation is.
That's fine with me, Judge.
Defense, do you have any? So you don't want a separate instruction in the final instructions what stipulations are, and that they would be included in a joint stipulation submitted to the jury, which is all I'd say. Okay, I will consider that. And then, anything else before we go? This should be version 4 that we're on.
No, Judge, where did you get the language for the actual possession? Looking at the standard jury instruction, I don't see it.
No.
Under 10.15, so did you pull it from another standard?
From the aggravation by possession, discharge, and discharge causing death.
Right.
So what'd you say you were looking at 10.15?
10.5 is the standard USCF, so just asking the definition of the actual possession.
3.3D.
Yeah, it would not be in 10.15.
Right.
Anything else on that?
Acting state?
All right, so again, I'll circulate that. Anything else before we go off the record?
Yes, sir.
And so the 2 placeholders we talked about, heat of passion and culpable negligence, are in comment sections. So they're not in there, but the instruction that would be included is often a comment. So where it would go. So just so that's not, it hasn't been lost.
Oh, got it. I understand what you're saying. Yes, sir.
You'll see it when you get it, yeah. But won't print that nice.
Got it.
Because when you print it when it has a comment section, it makes everything smaller and kind of worthless. All right. Okay, I think that's it for tonight then.
When should we be back tomorrow?
A few minutes ahead of time, I don't think. What's tomorrow, Thursday?
Tomorrow's Thursday, yes, sir.
I think I might have a plea or 2, but yeah, for this case, I think just 8:45 or whatever. It's fine, yeah.